Good afternoon and welcome to the Appellate Division First Department. I'm going to be calling the calendar. I see we have over 6 hours of argument, so I have to ask you to please just ask for the time that you really need. You're probably aware that we've had your briefs and your records for some time now, so we're familiar with the cases. I just want to get to the really important arguments that you would like to make. You know, when we put the lights on, when the white light goes on, you have 2 minutes left. When the red light goes on, you're supposed to stop. You can finish your sentence. Of course, if we judges have additional questions, we will continue to ask you. So I would appreciate if you could cut your times down accordingly. The first case is People versus Robert Jones. 4, 1, and 3. Okay, thank you very much. Camara versus Costco Wholesale. Excuse me? Submit. You want to submit? Anybody have? So, do you want to argue? And the other 2 people are just going to submit? Well, I'll take 2 minutes. Okay, 2 and 2. All right. D. Tiani, that's a submission. Rivera versus Slade Industries. Appellate, form 1, please. Okay. Okay, thank you very much. Tizoko versus GE and Low Corp.
Appellate, we request 4 minutes. Good afternoon. Respondent, we also request 4 minutes.
Okay, 4 and 4. 113-117 Realty versus DHCR.
Appellate, we have 5 and 3, please.
And the other respondent?
Respondent request 5.
Okay, 5, 2, and 5. People versus SEC is submitted. Miami Firefighters versus Icon.
Appellant, Your Honor, I have 6 and 2.
Okay, and
Respondents, there are 2 respondents, Your Honor. Collectively request 8, 6 and 2.
well, you don't have a cross appeals. Oh, one person's going to take.
There are 2 respondent groups, filed 2 briefs.
Right. Okay. So you want 8 amongst you?
Collectively 8 minutes, Your Honor.
Okay, so you can divide it up however you want. You want 6, one person wants 6 and one wants 2, is that it? Okay, that's fine. Thank you. People versus James Kelly. Okay, and the respondent? Okay, thank you very much. Whitfield versus City of New York.
Request 5 minutes, Your Honor.
Okay.
2 on rebuttal.
Okay, and respondent? Okay, thank you very much. 5, 2, and 4 is it. Cabrera versus UPS or Lincoln Square. Okay, and the other appellant UPS? And the respondent? Excellent, thank you. Who do you represent, I'm sorry? Did you put in a brief? Okay, and how much time are you asking for? 5. Okay. De Silva versus Toll First Avenue. Okay. Your casino, right? Okay, and respondent? Okay. People versus Pantaleone. Okay, you got it. Frazier versus Brand. Okay, thank you. Rodriguez versus Milton Baran. Okay. Laurent versus Laurent is submitted. Quick Park 808 is submitted. And North American Elite versus Space Needle. All right, that's what I gave you. And you have, right, okay, excellent. Thank you very much. Okay, the first case for oral argument, People versus Robert Jones. Okay, counsel, you may begin.
Thank you. Good afternoon. My name is Elizabeth Caldwell, and I represent Mr. Robert Jones. May it please the court. Mr. Jones has experienced tremendous tragedy since a very young age, and that includes the loss of 3 brothers, sexual abuse, and a near-death accident, all before his early teenage years. These traumatic events precipitated a cycle of addiction, mental health problems, physical ailments, and unfortunately, periods of incarceration. However, Mr. Jones's life has recently changed as he now has the support of his family, and he has taken new steps to address his underlying physical and mental health problems. We asked the court to reduce Mr. Jones's sentence from 10 to 7 years so that he could be released in 2024 at the age of 60 and can return to his family so that they can care for him and support his path to recovery. Mr. Jones's early life was marked by repeated tragedies. Not only was he raised in a poor family by his mother who did not read or write, but he also...
Counselor, I noted in your brief, you kind of glossed over his past criminal history. And I know you just stated that he wants to return to the loving arms of his family, but there were other periods in his life and during his criminal history where there was also a loving family. So here, you're requesting, I believe, 7 and 5. He was sentenced to 10 and 5. He committed how many burglaries? 4 burglaries, is that correct?
That's correct, Your Honor.
And then there was another burglary in Kings County, is that correct?
That's right, Your Honor.
And he also had how many prior burglaries?
He has 7 prior felony convictions.
And how many federal convictions?
3.
I see. And this was a plea bargain, is that correct?
That's right, Your Honor.
And it was a pretty good deal, I mean, given his criminal history.
We would disagree, Your Honor. Mr. Jones, while he did plead guilty and took full responsibility for these crimes, the sentence here does not adequately account for all of the mitigating circumstances in his life.
Evening, I know you said in your papers that no one was at home. However, my understanding was this was like in the afternoon or early evening. Is that correct?
That's right, Your Honor.
And so wherein no one was home, it was kind of just fortuitous that no one was home because it was quite possible that someone would have been coming home from work or from wherever. Is that correct?
Yes, Your Honor, it's true that no one was home and someone could have been home. But again, Mr. Jones did plead guilty to the full indictment here. He took responsibility, and that shows his remorse for the actions he took.
Well, he took responsibility, and he pled guilty, and the promise was, and the sentence imposed, based upon his background, based upon his taking responsibility, he was sentenced to 10 years plus 5 years post-release supervision.
That's right, Your Honor. But
and again, a plea bargain. Is that correct?
That's correct, Your Honor.
Didn't the people ask for 15 years?
That's right, Your Honor.
The court went down 5, went to 10, even though the people wanted 15.
That's right, Your Honor. The court
got
did
it.
offer, I'm sorry.
Thank you.
The court did offer Mr. Jones the 10-year plea bargain, and
it could have been consecutive time, could it not?
It could have, Your Honor.
Because these were 4 separate burglaries.
That's correct, Your Honor.
And this plea also covered a 5th burglary in Brooklyn, I believe.
Actually, no, Your Honor, it did not cover that. Mr. Jones separately pled guilty in his Brooklyn case.
Right, and in
He
that
was,
case, it was 3 to 6. So this 10 plus 5 years post-release ran concurrent with the 3 to 6 that he was to be sentenced to in Kings.
that's correct, Your Honor.
So, thank you.
Thank you. We ask the court to reduce Mr. Jones's sentence.
Okay, you'll have 1 minute on rebuttal. Thank you.
Good afternoon, and may it please the court. Stephen Kress on behalf of the people. There are really only two additional points that I would want to make. One is that the sentence in this case was also run nunc pro tunc with the sentence imposed in the Kings County case.
But that's only saved him, what, 6 months?
About 8 months, Your Honor,
8
yes. It did shave about 8 months off.
What were the federal convictions for?
I'm not sure, Your Honor. I actually don't remember at the time. And the only other thing I would add is that the judge in this case actually denied this exact request. The defendant asked for his sentence to be reduced to 7 years, and the judge said, no, I think I've listened to everything that you have to say, and I think 10 years is a fair and appropriate sentence, and I would ask the court to affirm.
Okay, thank you.
Your Honors, just briefly, Mr. Jones did take responsibility in this case by pleading guilty, and the sentence reflected here does not adequately take into account the tremendous tragedy that he experienced and also the fact that he's in a different place in his life now than he was during the rest of his criminal history. Mr. Jones has significant medical problems, which are detailed in our brief. He now is walking with a cane. He suffered a serious spinal injury in the year prior to the offense. And given that even if his sentence is reduced to 7 years, that would be 7 years later. And unfortunately, his medical condition is deteriorating in prison. So given the circumstances of his life in terms of his age, his medical problems, and the fact that there did seem to be a change in his life around the time of this offense, he was seeking new mental health treatment, he was seeking alcohol treatment, and he found his family after many years. So for those reasons, we ask the court to reduce his sentence. Thank you.
Okay, thank you very much. Thank you both. Aston Camara versus Costco Wholesale Corporation. Justice Moulton is disqualified from hearing this case. Okay, counsel, you represent Tiago, correct?
Yes, Your Honor.
Okay. You have 2 minutes, so please proceed.
Thank you, Your Honor. Good afternoon, may it please the court. Angela Williams, attorney with the law firm of Traub Lieberman, on behalf of Tiago Holdings. Your Honor, the most crucial question presented today is if the lower court failed to apply the appropriate standard in evaluating whether the alleged trivial defect is actionable. We submit to the court that the answer is yes, and the arguments presented will show that the lower court failed to properly follow the instruction of the Hutchinson case in providing the outline for what the court should consider when determining whether a trivial defect exists. The Court of Appeals found the circumstances under which a court should evaluate a motion for summary judgment based on a trivial defect in Tenant versus County of Suffolk, as well as Hutchinson versus Sheridan Hill Corp. The court held that the alleged defects dimensions, the presence of other defects in the vicinity, poor lighting, abruptness of the height differential, and whether the defect is hitting, difficult to observe, to pass over safely on foot in light of the circumstances. Those are the factors that should be considered when determining whether a defect is trivial. We submit that the lower
So why
court—
is this not a why are you're arguing that this is a trivial defect?
Yes, Your Honor.
And why would it be a trivial defect? What did you present to show that it was a trivial defect? Because I thought your own expert said that it looked like the area had been patched and it looked like an unauthorized patch job had been done.
No, Your Honor. In fact, our expert, James Fordham, measured the defect, and he described the defect as so insignificant as it is less than the thickness of 2 nickels. In his opinion, the floor was properly maintained and the defect was negligible.
I actually thought your person testified that he thought that the patch job was substandard work.
Right, that's what I thought.
Actually, Your Honor, what our witness testified is that the patchwork was not necessarily appealing. He never said that it was, he described it as shoddy.
Yeah.
However, in his opinion, it was not.
Yeah, Mr. Classy, right?
Yeah.
Yes, Your Honor.
So Mr. Classy was testified that it seemed to be a form of repair that was unauthorized, ill-advised, and that it was substandard work and not something that was considered professional.
Yes, but however, it was more of a visual opinion of his. He testified that it did not look appealing and it was not an attractive patch job. However, he's not an engineer. That was just his own personal opinion of the appearance of the patchwork. However, the expert testified that it was in fact a negligible defect as the dimensions were so insignificant.
So the red light is on, but I just wanted to say that Fordham, who is your expert, he didn't measure the jagged crack. Is that correct?
That is not correct, Your Honor. He actually measured the entire sprawling area.
Okay.
And
All right. Thank you very much. We will take a look at that. I think we're going to hear from the respondent. I gave you 2 minutes also. Thank you very much.
Thank you.
Good afternoon, David Tolchin for the plaintiff respondent. I just want to add that Mr. Fordham did the measurements. He didn't measure everything. He measured selective things, and the court below found that he did not measure the particular jagged crack.
Right. He didn't measure the jagged crack. He measured the area in the spalled area, right? And he measured that to be less than 9/64 of an inch, right?
Yes, and he did this 2.5 years after.
And that was the other thing, that this was done 2.5 years after the incident. And I think there was something in the record also that there could have been changes to the area during that 2.5-year period of time.
That's right, and their policy at Costco is to change, is to repair, and as soon as they get a report of an accident, they go there and they fix it. If it's a spill, they clean it up. So after 2.5 years, and this is in the main entrance to this major wholesale store, it would be speculative to think that they didn't change it within the 2.5 years.
Counsel was referring to the Hutchinson case, but I thought the Hutchinson case suggested that we should consider the area evidence regarding the condition of the floor area surrounding the defect, which was not done by their expert, and that generally the issue of whether or not a defect is trivial would be something for a jury, except in extraordinary circumstances. Here it seems like there's some conflict between your experts and.
Yeah, so they concentrate, the defendants here, they concentrate on, just look at the size, look at its 2 nickels, but they say don't pay attention just to the size, look at all the other surrounding circumstances. The videotape, they destroyed the videotape, and we don't have it, and I really think that we should have an opportunity to ask the court to instruct the jury about an adverse inference. Thank you, Your Honor.
Okay, thank you both for bringing up these points. We appreciate it. Have a good afternoon. The next case for oral argument is Rivera versus Slade Industries. Good afternoon, counsel, you may begin.
Good afternoon, may it please the court. James Sonigary for the appellant. The issue in this case, Your Honors, is whether an expert's opinion based on speculation is sufficient to defeat summary judgment motion. So plaintiff's expert said that the loss of power to the elevator, both elevators in fact, could have been caused by the fire department when they came in to release the plaintiff.
Counsel, what is the direct evidence of the interruption of power that you're claiming?
The primary evidence is, and direct evidence, is the mechanic who was called to the scene and got there and found that there was no power to the elevator.
Isn't that hearsay? I mean, he said that. He said that someone told him that. You're also drawing an inference, are you not, from the rope grippers?
He did say that someone told him that. That absolutely is correct. It's hearsay. But he also said that when he got there was no power, and he had to go to what's called the main disconnect to put the power on to both elevators, not just one elevator, both elevators. So there is direct evidence. There's deposition testimony from the mechanic who was called to the scene to say the power was out in both elevators, and he had to go and put the power back on to both elevators. Now, contrary to that, the plaintiff's expert says, well, maybe the fire department turned the power off. There's absolutely nothing in the record to show that. There's no evidence of that whatsoever. Secondly, plaintiff's expert says that, well, there may have been a problem with the brakes. However, the mechanic, again, who was called to the scene on the day of the incident, was asked during his deposition, what did you do? And he said, I turned the power on, I checked the brakes, because he was specifically asked, could a problem with the brakes have caused this shaking? The answer was yes. Did you check the brakes? I did. They were fine. Once he turned the power back on, he then rode the elevator. There were no problems with riding the elevator, no problem with the operation of the elevator, no problem with the brakes. So again, the direct evidence is there's no problem with the brakes. Plaintiff's expert simply speculating that there's a problem with the brakes.
See, counsel, that's what I don't understand. This was your motion for summary judgment. You're speculating that was a loss of power because they were testing the generator that caused this incident. And you're arguing that plaintiffs are speculating. So given the fact that we're talking about a motion for summary judgment, seems to be speculation, therefore, on both sides. So why not just proceed? I mean, obviously there are issues of fact, right? Issues of speculation.
I respectfully disagree. Obviously, if that's your Honor's view, then I understand.
That was my question.
I understand. Well, what I'm saying is that I don't believe that ours is speculation. There is no question that the power was out, and there's no question that when the power was out to both of the elevators, it means a loss of power to both elevators. If it were just one elevator, there may be an issue. Loss of power to both elevators means that they shut the power off to both elevators. So we have, based on that there was some type of issue with the building power.
But the power was not off for the rest of the building. Wasn't the power on for the rest of the building?
Yes, but that's not unusual.
I'm sorry?
When you do the elevator testing, you shut the power off to the elevators and not to the rest of the building.
So counsel, who shuts the power? Who would shut the power off to the elevator?
The building.
Did you get an affidavit from the building saying?
No, unfortunately, Your Honor, I did not.
Okay, then that's a problem, don't you think?
I wish we had done that. My
Yeah.
life would be a lot easier.
Coulda, woulda, shoulda, yeah.
So how do we know that it was the building that shut the power off?
Well, they're the only ones that have access to the power.
Ooh, sounds like speculation again.
They're the only ones that have, well, respectfully, Your Honor, there's no one else that has access to the power in that building other than the building.
You're missing an affidavit.
Yeah.
I understand, Your Honors. I wish it had been done. It would make my
Yep.
life easier.
Okay, well.
Thank you, Your Honors.
We'll hear from the respondent, and then you'll have a minute to respond to that, okay? Thank you.
Good afternoon, Your Honors. May it please the court. Lisa Comeau for the plaintiff respondent. There are not only multiple issues of fact here, there are like layers of issues of fact here. At the outset, This is a Res ipsa case in addition to anything else. I think we lay that out very clearly in our brief. The case law, it's sort of the proverbial.
Your plaintiff testified, your client testified that when he got into the elevator, it went up and then it dropped,
Correct.
right? Which is kind of contrary to a power loss, I would think, because it sounds like bouncing rather than if it's a power loss, nothing's moving.
Right. It actually, based on the defense witness's own testimony, that sounds like a brake and/or controller problem based on what they themselves
Yeah, because my
described.
understanding of how these mechanics work, the power loss, if there's a power loss, those brakes lock on fast. They're not going to let you move.
Precisely, Your Honor. And that's the other point, is that even if you wanted to assume, just for the sake of argument, I mean, I completely disagree, but if you want to say, oh, well, yeah, there was generator testing and there must have been a power cut, this still never should have happened. The testimony from the witnesses themselves, from the defense mechanics.
They got witnesses from everybody, except I already mentioned the one witness that I would like to have heard from is the building that would have told us whether or not there was a power loss.
Yeah.
That would have been, the case would have been over at that point, right?
Yeah,
One way
I
or
think
the other.
actually there's some problem because it's a correctional facility, and I don't know the particulars myself, but I think there was some issue there. But in any event.
Counsel, Mr. Ryan, who's the defense witness, actually said as much what you just said, which is that it wouldn't drop in the course of a power failure, correct?
They all said that, Your Honor. Mr. Ryan said it, plaintiff's expert said it, and also the defense expert. I mean, counsel started out saying that plaintiff's expert gave speculative opinions, but in fact, it was the defense expert who didn't even assume the correct facts as to the manner in which the accident occurred. So, I mean, it's laid out, I think, in detail in our brief, so I don't want to belabor it unless the court has more questions, but I would respectfully submit that they did not meet their burden, that this is, number one, a res ipsa case, which obviates the issue of notice anyway, and number two, there's ample evidence to support a jury finding of actual negligence in the maintenance of the elevator, because there's also proof that there were previous problems, there are very sketchy records from the elevator company as to what was done on prior occasions, and it looks like there was a root problem that had caused the same type of thing to happen previously that was never addressed. It was like the symptoms were addressed, the elevator was put back in service, but it's very likely that there is another root problem, and we do not have detailed or significant records after the fact to find out whether it happened again, which also is very likely. So based on all of those things and for the reasons stated in our brief, I'd respectfully ask the court to affirm the order appealed from. Thank you.
Thank you.
Your Honors, understand my position. If there are no questions, I certainly can stop talking.
Any more questions? Okay, I think you've answered them all. Thank you both very much. Have a nice afternoon. Tizoko versus GE and LO Corp. Okay. Good afternoon, counsel. You may begin.
Hey, good afternoon. My name is Michael Samuel, and I'm representing the appellants in this matter. This is a case brought under the New York labor law for wage and hour violations by the respondent. Plaintiffs in the underlying action filed a summary judgment.
We know, and the case was dismissed sua sponte. I don't think I would belabor that was incorrect. So why don't you go on to the merits?
Okay, I mean, that was solely what I was going to address today, is that it shouldn't have been dismissed sua sponte. It's our position that the case should be reinstated, and that summary judgment should have been granted in the underlying action.
And so why should summary judgment have been granted, Counselor?
Well, we submitted affidavits from all the plaintiffs saying how many hours they worked. We have deposition testimony from the defendant, which corroborates the amount of hours that they worked. So there's really no issue of fact.
So the defendant actually stated that they never paid overtime, that the plaintiffs were paid a flat fee, a flat salary, regardless of how many hours they worked. Is that correct?
Right, that's our position, and that violates the hospitality wage order.
And was there anything in terms of any tip notice or tip credit notice to the plaintiffs?
No, there's nothing in the record that shows the defendants provided any tip credit notice.
In fact, there was no record keeping at all in 2016. Is that correct?
Right, there was no record keeping, and as your honors are aware, that obligation is on the defendants, not on the plaintiffs.
Remember when they started using time cards, it was inconsistent. The use of the time cards was inconsistent. That was the testimony, is that correct?
Right, it was very inconsistent and therefore unreliable, and the time cards that were put into evidence were not properly authenticated, and therefore they should not have been considered at the lower court.
Anything else? Oh, well, thank you very much.
All right, thank you.
Good afternoon, Your Honors. May it please the court, Demetrius Adamus for the respondent defendants. Again, as I think the court has already brought up, the point here is this was a summary judgment motion. And while Justice Mills may have taken a rather unorthodox position on trying to resolve the matter, what she did state in her order that a thorough investigation of the specific facts and alleged violations was needed by, in this case, she was wanting to refer this to the Department of Labor.
Your clients, in their deposition testimony, specifically stated that these individuals, these employees, were paid a flat rate, regardless of the number of days they worked or the number of hours they worked per day. That there was a flat rate, that there was no overtime paid to these individuals.
Well, that's, again, that's each employee had a certain set hours. And again, this was, and part of this was at the behest of the employees. They also worked many different shifts, many different jobs. And again,
Counsel, you're in a tough spot because the weekly wage resulted into like $4 an hour here, you know, or less for some of these workers.
well, again,
So that's not, I mean, there's nothing, show us an issue of triable facts.
well, what we
concerning
have
that
is
wage theft.
the appellants basically have listed, number one, all the plaintiffs basically listing working, there was one at 46.5 hours, but everyone else in excess of 50 hours, which goes against the time records, which again, as the court pointed out.
What time records? What time records? Because it was my understanding that no records were kept.
Well, in 2016.
No
we-
personnel
Do
records.
me a favor, let the judges finish the question,
sorry.
and then we'll let you
Sorry.
answer.
No personnel records. The testimony by your clients was that no personnel records were kept. And also that the time cards were kept as of 2016. But again, the testimony from your client was that the use of those time cards was inconsistent, meaning there was no real requirement that the employees clock in or clock out.
No, there was always a requirement. The inconsistency was on a part of the employees failing to follow the rules. And again, but again, those are
But that's not, that really doesn't excuse your paying them for the hours. I mean, they testified as the hours. Nobody on behalf of your client testified that, oh no, they didn't work those hours. They were many of them were very long-time employees of your store, and worked these hours for many years, they testified.
Well, I would point out that again, in the time card submitted for the period, there were weeks where these employees worked only 11, 13, 17, you know, much different hours. So
Well,
again,
that's all well and good, but the statute doesn't say that at the end of the year, we add up all the hours and we see whether or not that falls within the minimum wage or does not. That's not how it works. You have one plaintiff, I think it was Galindo, who worked as a chef. He said he worked 50 to 61 hours per week, and he would be paid $500 per week until 2015, and then his pay was raised at some point in time to $675. That's below the minimum wage, even below the minimum wage for 2015.
well, again, and I know the red light is on, but just to
Please
answer that,
yeah.
again, but the pay has to track the hours. And we have a much different story in terms of the hours. Final point, one of the plaintiffs here, Margarito Torres, actually signed a release, releasing the respondent defendants from any claims here. So I think there is enough here to warrant the denial of summary judgment and let the trier of fact make their decision. Thank you.
Okay, thank you both very much. The next case for argument is 113-117 Realty versus DHCR.
Good afternoon, Your Honors. My name is Santo Galino. May it please the court, I represent the appellant landlord 113-117 Realty. Fairly straightforward Article 78. Should the DHCR have stayed its underlying proceeding while we prosecuted a housing court proceeding against this tenant for causing damage to her apartment?
But even in investigating this particular claim, didn't the DHCR find that there was no evidence that you would put forward to show that, in fact, the tenant or any of her guests had caused any damage to this apartment?
Well, Judge, all the evidence is circumstantial. The photographs in the record and in the administrative return show that the damage is not normal wear and tear. How does a Formica counter get broken in multiple parts? How do cabinet doors?
There was some testimony and also from the investigation that some of the issues were because of incomplete work done by you, the landlord. That there was incomplete in terms of fixtures, that the renovation had been started years before. For example, incomplete installation of the kitchen sink, faulty kitchen window sashes, damaged bathroom tiles, improperly installed bathroom tub shower water valve. Also, incomplete painting on the entire drywall of several rooms. So is it your argument that the tenant and or her guests were the ones who caused the damage, where the record shows that the kitchen sink, et cetera, was because of incomplete installation?
So with the kitchen sink, that's a distraction that the agency created. After my client was invited into the apartment for the first time in the 5.5 years that they owned the building, and was shocked by what they saw, they installed a replacement sink as a temporary measure so the tenant could have a working sink and running water, et cetera. And they've tried to turn that installation as to some kind of defect that my client is responsible for. There's no way, if you look
Why was it necessary to replace the kitchen sink?
It was totally destroyed. It wasn't...
So it wasn't because it was improperly installed initially.
Correct.
It was because your argument is the tenants did something to the kitchen sink.
That's correct, Judge. And if you look...
what do you have in support of that?
Well, Judge, if you look at the photographs, if you look at the, underneath, missing cabinet doors, the toilet seat on page 52 of the record. I mean, this doesn't just happen from normal wear and tear.
What about the incomplete painting on the drywall of several rooms? What did the tenant do?
We did not see that, nor did we allege that as part of our case. We don't know if that's actually accurate.
What about the improperly installed bathtub shower water valve? What did the tenant do with that?
We believe it was broken, not improperly installed, Judge. And in fact, if you look at the report, the DHCR order, on I think it's item number 12, they say tiles were broken, not that tiles were missing, not that tiles became defective. Tiles don't break unless somebody strikes them and damages them. So you have agency precedent to have stayed the proceeding, right? We're not asking to reverse the order. All we're asking is to remand this back to the agency and let us do our thing in housing court to determine who caused it, because those are the defense.
Wait a second, to do that, that would be, the way I understand it, the administrative record here, or the administrative determination, is an estoppel argument against you in the civil proceeding. So if we were to do that, you get another bite of the apple, wouldn't
Well,
you?
no, our case was started first, Judge. This case never should have gone forward. When we notified the agency of the pending holdover, we asked them for a stay. We said, please, in accordance with your precedent, please stay your proceeding.
And they didn't stay it, right?
No, they did not.
Did you then commence a Supreme Court action to stay that DCR?
No. That's a confusion by Justice Edmead. She seemed to think that the Article 78 was asking for a stay at that proceeding. That was just our Article 78 saying this order never should have been issued because it should have been held in abeyance pending the housing court
No, she
proceeding.
didn't make a mistake. You could have commenced an Article 78 seeking a stay.
No, we commenced an Article 78 seeking to modify the decision of the agency, not to seek a stay of the, at that point, the order was already issued. There was nothing to stay. We were asking for it to go back so that the agency could hold it until we did our thing in housing court.
Okay, let's hear from the respondent, and then we'll hear back from you.
Good afternoon, Your Honors. My name is Martin Schneider for the New York State Division of Housing and Community Renewal.
So, counsel, is Mr. Galino correct that your normal procedure would be to stay this type of proceeding pending the other proceeding he had already started in housing court?
Not this type of proceeding, Your Honor, because the proceeding that he has instituted in housing court is a proceeding for nuisance holdover.
Right.
This proceeding is to determine, the DHR proceeding is to determine whether the tenant is receiving all of the services for which he is paying rent. It's two different causes of action. It's two different animals, and one has really nothing to do or is not dependent on the other. It's not the same as a court proceeding that is trying to...
So there won't be an estoppel effect based on what you're just saying. There won't be an estoppel because they're two different animals, two different issues.
Two different animals, and the individual service findings will not necessarily coincide. It's not the same as if there was an overcharge case in court to find the legal rent, and then we were also trying to find the legal rent. Those are two proceedings that are trying to find the same exact thing. These are two different things. With regard to the kitchen sink, counsel has stated that they installed the kitchen sink, and our inspector found that the kitchen sink was not properly installed. It is not fastened to the countertop. Water is seeping down through the...
Well, I think he said that it was an emergency installation based upon your findings or your inspection.
The kitchen sink had to have been installed before our inspection because our inspector found the same thing that the tenant wrote on the complaint, that the kitchen sink was smaller than it used to be, that it's not properly installed, that the countertop was too short for the base, for the sink base, and these are undisputed findings.
These would not be, you also found, or your inspectors found, that this would not be something that would be caused by the tenant.
The landlord is admitting that he installed those things in that fashion. And whatever the condition was before the installation is irrelevant. The landlord came up and created this situation in the kitchen, and did not properly repair it, and it still subsists to this day, and the tenant is living with it, and our inspector found that it was unworkmanlike and a reduction in service for the tenant. And that undisputed reduction in service is enough to sustain a rent reduction, because under the statute, it doesn't matter how many multiple reductions in service there are, the penalty is the same as if it was for only one reduction of service.
You found 20, right? Didn't the inspector find 20?
We found 20. We found other things that were okay, but we found 20 that were not okay, and the penalty is the same as if we only found one. So with regard to this kitchen sink and countertop issue, which is not disputed, and the landlord concedes that he installed those things in that condition, the rent reduction should be affirmed. Thank you, Your Honor.
Thank you, counsel.
Marty. Well, contrary to what counsel just said, the conditions don't persist today, Judge. Because the housing court case is now moving along, it appears that the tenant on October 12th called in a complaint to HPD to come inspect the apartment. Almost all the same items were listed. The inspector went through the apartment and found that there were no violations, and the complaint was closed. This was last week.
So let me split this up so I can, in my mind, I understand what you're doing. You have a civil court nuisance holdover proceeding going forward, correct?
Correct.
So what happened in the administrative agency, that's not going to affect your holdover petition.
It does, Judge.
How?
The tenant's attorney, as soon as that order came out, we were on the verge of settling the case. Tenant's attorneys withdrew from the settlement when that order came out, so it does affect it.
So you didn't tell me.
Legally, procedurally.
Yeah, legally, what's it going to do to you?
Well, if we...
You could still win.
Yes, absolutely. And if we do win, the tenant causing the condition is an absolute defense to the rent reduction order.
Right.
So then we'd have to go back and reopen the rent reduction order at that time? That doesn't make it doesn't make sense to me, at least.
Well, one of the rent reduction issues was the smoke detector, or the lack of the smoke detector.
Right.
There was no smoke detector present in the apartment, but you didn't come forth with anything that you had ever issued a smoke detector to the tenant.
The prior owner installed a smoke detector, and under the administrative code, it's the tenant's responsibility to maintain it.
Well,
if the smoke detector was missing, it could only become missing if the tenant removed it. But I just want to point out two other things, because I know my time is limited. Like I said, agency precedent is to stay, but also to give, it's a defense. So if there's 20 items on there, even if some of those aren't tenant caused, the amount of work that my client would have to do to restore the rent is not as expansive. So where the tenant causes the condition, that's a defense. The second department in DiMartini versus Emicky, which totally got lost here, and I believe was controlling on the agency, at least until this court deems otherwise, it says it's incumbent on the agency when there is this type of an allegation to at least investigate if it was the tenant that caused the conditions. So here, we believe the tenants caused the condition. We started the holdover case. She then filed this complaint. This complaint should have been stayed until we have an outcome in housing court, because that would be a defense to the tenant's complaint.
Okay,
Thank you, Your
I
Honors.
think we got your point. We'll take a look. Thank you very much.
They will.
The next case for argument is Miami Firefighters Relief and Pension Fund versus Icon.
Good afternoon, Your Honors. Michael Klein for the plaintiff's appellants. Sorry. May it please the court. If the decision below is upheld, it will open the door to any defendant seeking dismissal of a complaint to submit an untested affidavit and will encourage trial judges to request such an affidavit when defendants profess innocence in a civil case, which, as we know, they almost always do. It will reverse the time-tested rule that allegations are deemed true and instead create the opposite inference, that whatever a defendant claims may be taken as true. Summary judgment and trial are for fact-finding, and that is where fact-finding should remain. Indeed, the Court of Appeals in Rivera, which is cited in our pleadings, notes that the mere fact that judged on the record, complaints and affidavits, the mere fact that judged on the complaint and affidavits alone, plaintiff could not withstand a motion for summary judgment under CPLR 3212, which requires the
Was there any
disclosure.
documentation accompanying the March affidavit?
I'm sorry, Your Honor?
I'm sorry, was there any backup documentation accompanying the March affidavit?
There was absolutely none, Your Honor.
Okay.
The March affidavit is 2 paragraphs, the first paragraph of which identifies Ms. March.
No, I have it in front of me, I know what it says.
Yeah, okay.
What about the demand futility? I mean, that which is sort of like a conditioned precedent to bringing these kinds of cases. You said that you did not have to make a demand, and I think the court found otherwise.
Demand futility is a conditioned precedent, Your Honor. And we believe that the court did not find that, well, the transcript is slightly confusing, but we don't think the court found that demand was futile as the Icon defendants, because first, the court ordering
Yeah, I looked at the transcript. There are two things going on in what the transcript was providing. It was the Rebelli case that he was talking about, where demand was made and was rejected. Then it dovetailed into this case, the Miami case, where there was no demand, correct?
That's correct, Your Honor.
And in this case here, it's unlike the other case that was referenced in the transcript, where you had an independent body or independent board reviewing the demand. This one had 7 directors, of which 2 were conceded to be interested and 2 were said to be not interested, but then there were the remaining 3 that were like, kind of, well, where are they at, right?
Your Honor, to clarify, I believe we challenged 3 of, there are 7 directors.
Yeah.
Right.
Without question or without challenge, 2 of them are essentially conceded to be interested.
Right.
And those are the directors who were appointed by Mr. Icon and who are represented by the same counsel as Mr. Icon.
Right.
They unquestionably, I believe, fall in appellant's camp today.
Right.
There are 3 other directors that we challenge, and I'll take them in 2 buckets, if that's okay. The first is Mr. Cristiadoro.
Let's do the easy one, the woman.
Ms. Krongard.
Right, Ms. Grove. That's the easy one, right? Because she came up, she voted against him on something else, correct? So that's not really.
She voted against what he wanted in connection with the proposed transaction where the board was unanimous.
Right.
That's not in our complaint. That was in the Ribby complaint.
Right.
And
Well, that kind of shows that where
it was
she
counted as a
lied.
concession. But, Your Honor, she also stated when she was serving on the board of Xerox that she would only do so if it would placate
You know,
Mr.
putting her aside,
Okay,
if you get the 2 others, you got the 4.
We can set her aside, correct, because we don't need her. One of them is Mr. Cristiadoro, who is a managing director for the Icon defendants, less than 3 years before the case was filed, and who sits on at least 11 boards of directors of large companies, as we allege, and is paid for his service on all of those. He has a long-standing business relationship with Mr. Icon that continues because he serves as Mr. Icon's representative on at least 11 boards of directors. And as the court, I'm sure, is aware, each of those boards of directors of publicly traded companies generally pays handsomely. In the Tsutsui case in the second department, the court found that, and let me just step back if I can.
Just tell me about the other guy. What's the other guy?
The other guy, his name is John Visentin. He's the CEO of Xerox now. He consulted for the Icon defendants immediately before becoming the CEO of Xerox, was placed into his position as the CEO of Xerox by the Icon defendants. And we allege in paragraph 21 of our complaint that the Icon defendants removed the prior 2 CEOs of Xerox. He's making $13 million a year. He made $13 million in his first year at Xerox. And we think there's a reasonable inference that he was well paid as a consultant for the Icon defendants because he went straight from that into a $13 million a year job. But by comparison, Your Honors, in the Tsutsui case in the second department, and if I could step back just for 1 second, I apologize, but the court applied the wrong test to demand futility as well. He said that we hadn't established that the directors were so beholden to Mr. Icon that he exercises complete dominion and control over them, that is not the test for demand futility. The test for demand futility, as explained in the Kenneth Cole case by the Court of Appeals, is that we have to allege a reasonably conceivable set of facts that a director's discretion would be compromised by the influence of the person who would be asking the director to sue. And we submit that that's true as to the CEO because he consulted for Mr. Icahn literally the day before he became the CEO of Xerox, and it's true of Mr. Crisciadoro because of a long-standing relationship that continues to this day and results in the service on several boards.
Okay, does anyone have any? Go ahead.
I have one question to ask. The deal never went through, right? The whole thing about buying or at least acquiring HP never went through. So
that's correct, Your Honor,
that's what Justice Ostriger was saying, no harm, no foul. At the end of the day, everybody was still where they were at.
Everybody, we don't know that everybody was where they're at, Your Honor, and the reason for that is because there's no question that Mr. Icahn had a paper profit of close to $250 million before the deal was scuttled. There's no question that Mr. Icahn was...
Yeah, he ends up with the claim here, at least I understand, is that they use confidential information, the Xerox confidential information to buy HP stock right before the deal. That's sort of the allegation, correct?
That is the allegation.
That's the allegation. Great. I want you to confirm that. So at the end of the day, they never went through. So they got a bunch of HP stock that they're holding now that nobody wants.
Except, Your Honor, the deal never went through. Mr. Icahn admitted on CNBC, and it's page 903 to 905 of the record, that he was well hedged and held billions of dollars in S&P 500 shorts. It's certainly reasonably conceivable, and we submit likely, that Mr. Icahn had hedged that position among his other positions and may have retained some of the profits. The law is clear, and the case is Diamond against Oriamanu, and it says that if a fiduciary or someone who comes into confidential information through a special relationship profits off that information, that profit belongs to the company. And that's why we're here suing derivatively on behalf of Xerox. There's a more than reasonable inference that whether Mr. Icahn is among the most sophisticated investors in the world, there's no question about that. And he knows how to divorce his economic holdings. He knows how to divorce his voting control from his holdings. He knows how to hedge himself. He knows how to hedge himself well.
Thank you.
And
I got it.
there's proof he was hedged.
You'll have a couple minutes for
Thank you,
rebuttal.
Your
Thank
Honor.
you very much. So tell me who you are and how much time you're going to take.
Good afternoon, Your Honor. Samir Advani from Wilkie, Farr & Gallagher on behalf of Xerox Holdings Corporation. I'll be addressing the issues relating to demand futility, and I'm going to be taking 6 minutes.
Okay.
Counsel for the ICON entities will take 2 minutes.
Okay, thank you very much. You may proceed.
May it please the court. Your Honors, this is a derivative case. And as Your Honors have noted, the threshold issue here is demand futility. If the plaintiffs cannot meet their burden under New York law to show that demand was futile, there's no issue about whether or not Mr. Icahn suffered a loss.
We obviously understand that, so that's why we had a whole long discussion with plaintiff's counsel, and he went through each one of the people.
Right.
So are you telling us that our reading that his interpretation is wrong, and are those 3 people? 2, I think they agree we're not interested. 2 seem to be represented by Icahn counsel. They are interested. So we got 3 people.
As to those 3, Your Honor, happy. And one clarification to Justice Owing, your point about the companion case, Ruby, that was heard at the same time. That case had the same 3 claims that were added after the appellants filed their case, and they didn't make a demand there. So the demand excusal was in both cases. And that's why the court dealt with Ruby first.
But different set of individuals, though, right? Not the same.
No, the exact same individuals.
Okay.
Same claims, unjust enrichment, breach of contract, and breach of fiduciary duty. And so the court went through the Ribby case first because it had other claims as well, ruled that demand was not futile, and then moved to the appellant's case and concluded, he said, for the same reasons, I'm going to dismiss both cases. And so the threshold issue was decided that demand was not futile and they're not allowed to proceed. There's to be really no issue as to any other parts of the case. Now, as to the defendants...
Yeah, but see, the problem, you just highlighted, at least for me, the problem was that you had different set of individuals. You had the Ribby individuals who were an independent board, and then you have these individuals in this Miami case, which were 7 individuals that you know, for the court to say, for the reasons I stated on Ribby, I'm going to apply it to Miami, you guys should have made a demand. That's kind of, without going through at least the two, and then the three challenged individuals, kind of makes it a little bit hard to really say that the demand was not futile.
Well, Your Honor, it's the same claims, same 7 directors.
I get the same claims.
Right.
You said same set of directors?
Correct. Yes, Your Honor.
On
It's the
both
same-
sides?
In both sides. Both cases, we're talking about the same 7 directors because these claims were filed in December and the Ribby plaintiffs amended their complaint in January. So they are the same claims.
I'm confused because I thought Justice Ostrager was talking about where there was a board that rejected the demand. Am I looking at the wrong case?
Those are 2 claims that Ribby had in his original complaint. So that's why Ribby was a broader case. There were some elements of claims that they made a demand, but they also added the same 3 claims against the ICON defendants that appellants have in their complaint. And that's
Oh, so
why.
there were 2 universes on the Ribby. There was 2 universes.
Correct.
Oh,
Exactly.
got it.
There were 7 counts in Ribby. And so the overlapping counts were 3, 4, and 5 in Ribby that
The
matched.
one that he said about applying the Ribby demand fertility to the Miami would involve the same set of 7 individuals.
Absolutely the same. And in the transcript on pages 35 to 40,
Yeah, I
Ribby's
read it.
counsel argues breach of contract, unjust enrichment, and breach of fiduciary duty, which are the same claims that appellants have in their complaint. So as to those 3 directors in the middle, in their reply brief, they discuss Ms. Krongard in a footnote. And I think, Justice Ong, you hit it on the head. That's the easy one because her public actions, which included in litigation before this court in 2018 about the board's business judgment on the merger with Fuji, show that it's just not credible to suggest that she's beholden. With respect to the remaining 2 directors, the real issue in their papers is that they were appointed
Well, the
by
problem
Mr.
that I see
Icahn.
is that, unless I overlooked it because it was a pretty lengthy transcript, I didn't see the Supreme Court going through the analysis or at least the discussion of the two individuals that we're talking about now.
Well, they heard argument on it. Certainly they heard argument on it.
I heard argument, but I didn't get the benefit of the court's thinking about it at the end of the day, right?
Well, at the end of argument, the court said, I'd heard all I needed to hear about demand futility. I'm going to dismiss it on the grounds that demand is not futile as to a majority of the board. And that was the court's expression of, his conclusion. And those 2 directors, really, all it is about past business relationships. And as I think counsel alluded to the Kenneth Cole case, the Court of Appeals made very clear that past relationships are just not enough, especially in a case like this.
Well, I mean, it seems to me it was more than just past business relationships. And I know that that's what the Kenneth Cole case says, but one of them, Mr. Christodoro, I mean, he was on 10 other boards as ICON's representative. I mean, he was appointed all the time to represent him and his interests. So I think that was certainly one of the things. It was a lot more than what you're saying.
Well, as to that, Your Honor, I'm glad counsel brought up the Tsutsui case in the Second Department, because I think that actually highlights the deficiencies in the pleadings here. In that case, the court focused on one defendant, which they cite in their reply case, where he was a lawyer who had a 3-man law firm, and the plaintiffs there pled that he had received $1 million in fees from the defendants in the 2 years leading up to the complaint. So they pled the amount, they pled that it would have been material to a small firm, and it was at the time the complaint was filed. Here, we have no allegations about how much was received, whether it was material, and we're talking about, Mr. Christodoro used to work for Mr. Icahn, but it was 3 years before this complaint was filed. Mr. Byzantine had a several-month consultancy arrangement, almost 18 months before the complaint was filed. So I think the Tsutsui case actually highlights the deficiencies here with respect to demand, and that's why we argue in our papers that they haven't carried their burden to overcome the presumption of independence that attaches under New York law to directors and show that demand is futile, and that they have standing to pursue these cases on behalf of Xerox.
So you're telling me that when this complaint was filed, these 2 individuals were no longer in any way connected to the ICON entities?
Certainly, there's no allegation that at the time the complaint was filed, there was any employment relationship or consultancy relationship with Mr. Icahn. That is correct.
Thank you.
I see my time is up, Your Honors.
Okay, thank you very much. Okay. You may begin.
Good afternoon, Your Honors. May it please the court, Robert Vidicic on behalf of Carl Icahn, High River Limited Partnership, Icahn Capital, Keith Koza, and Nicholas Graziano. I'll be very brief. Simply note that the arguments about the affidavit is really just a red herring because these are indisputably all derivative claims, and as explained by Mr. Advani, the court found that the plaintiffs did not plead or show demand futility. And so while it's true that we provided additional grounds for dismissing this case, the fact of the matter, and in connection with that, provided an affidavit at the direction of the court during oral argument. The fact of the matter is that the whole issue about the affidavit is really academic.
Counsel, presume we agree with plaintiff. I'm not saying we do concerning demand futility. Is the March affidavit sufficient to show loss? And also, actually, let me amend that question. In a breach of fiduciary duty claim, can't one only seek nominal damages, not money, not money damages, not complete damages? You can get a dollar bill for a breach of fiduciary duty. Is that correct?
Well, I mean,
is it correct, though? I mean, I may be mistaken. I thought that was the case, that you could seek nominal damages in breach of fiduciary duty claims.
I believe that's often the case. Of course, I mean...
So it doesn't matter, what follows from that, of course, and you correct me if I'm wrong, is that it doesn't matter about losses.
I think it matters. I mean, a couple of things here. One, again, we're presuming that a plaintiff has standing to bring such claims, which, we established is...
Yeah, no, I know. I'm just positing that.
I mean, counsel referred to the Diamond versus Oriano case. In that case, there was no dispute that there were profits made. There was no dispute about, that there was confidential information used. That's not the situation here. And not only that, they, in that case, only argued that it shouldn't be brought as a derivative action, that if there was any harm, it was not to the company, that it was only to their counterparties. And so while it may be true in certain situations that one can get nominal damages, I mean, Diamond versus Oriano isn't really opposite here. And the bottom line is that the court didn't have to require an affidavit. As I said, it's really academic because he already had decided clearly that there was no basis to proceed. They didn't have standard because of the failure to plead demand futility.
Okay, thank you very much.
Thank you.
Counsel, you have 2 minutes.
Your Honors, thank you. If I may clarify a few quick points. The Ribby case, which was argued before the Miami firefighters case, did not quite have the same 3 claims. It also had claims for breach of fiduciary duty, but the claims were much different. The claim that's most analogous was that the Icon defendants...
But is it incorrect to say that the individual, the 7 board members that we're talking about, the 7 individuals we're talking about were identical?
The board is the board.
The 7, not the independent board.
It's the same 7 directors.
The same 7.
Justice Wang, yes, but I'll note that your prior comment was correct, that there was no analysis. When the court
No,
said...
that's not correct. I went back and looked at the transcript here. It's interesting. Mr. Nespo doesn't really take any objection to the defendant's attorneys going through the individuals, at least the challenged individuals, as to their past business dealings. And I'm looking at Mr. Nespo's response to that. He doesn't say anything. He doesn't challenge anything. And then I'm looking at Mr. Klein's response, and he doesn't really, he kind of like talks around it a little bit.
I am Mr. Klein, and I addressed it as quickly as I could after the court had previously...
Page 52, right? 52,
the court had previously said, I heard all I want to hear about demand futility, and that immediately precedes my argument about demand futility. Mr. Nespol's arguments are in no way binding upon our client. The consolidation of arguments here caused confusion. It basically caused an adverse decision to Miami firefighters on different claims than Miami firefighters had before I stood up to argue.
So you were trying to clarify the vacuum that Mr. Nespol left.
I was trying to fill the vacuum that was there with,
right, I see it.
With the understanding that...
I didn't know who Klein was until you told me you're Mr. Klein.
With the understanding that the court had previously said that he had heard all he wanted to hear about demand futility. And just after that, the court cuts the argument. Respectfully, the court ended the argument and said, we're done for today. I didn't want the court to do that during my argument. If I could make 2 more very quick points.
All right, good, you have.
These are not the thin social circle relationships that Mr. Icahn has with Mr. Crisciodoro and Visenstein that Delaware refers to them. They worked for Mr. Icahn very, very soon before the complaint was filed, within 2 years, 2.5 years. They still have ongoing relationships with him, one with Mr. Icahn being the largest shareholder and a controlling and dominating shareholder of a company in which Mr. Visenstein is the CEO, and in which Mr. Icahn had deposed the prior 2 CEOs, removed them from their positions by his own admission. And the other still serves on 11 boards of directors for Mr. Icahn. He's handsomely paid, much more than the $300,000 that the one attorney from the Tsutsui case would have gotten over 2 years. It's significantly more than that. It can't be that demand was futile in the Tsutsui case and is not futile here. And we do know that demand was futile in the Tsutsui case. Thank you, Your Honors.
Okay. Thank you all very much. The next case for argument is People versus James Kelly. Okay, you can start now. Thank you. Good afternoon.
Good afternoon. My name is Hannah Gladstein for the appellant, Mr. Kelly. May it please the court. This court has squarely held that when a person is unable to complete a mandated treatment program because the program is unable to meet their medical needs, that person must either be given the opportunity to participate in a suitable program or to withdraw their plea before the court proceeds to impose sentence.
Well, did the defendant or his counsel ever state that the reason that he left the program, I think on 2 different occasions, if I'm not mistaken, that the reason he left the program on those occasions was because they were not meeting his mental health needs?
Your Honor, in this case, the matter was brought to the court at the first opportunity, really. When he left the program, under whatever circumstances happened, and he departed from the program the first time.
Well, under whatever circumstances was that he voluntarily left the program without permission. And I think, if I'm not mistaken, that he left the program the very next day.
At sentencing, he explained that the reason why he left was because they did not provide methadone, which he required. This was the first time that the court was hearing about that. When he returned on the warrant previously, he appeared once without counsel, and then by the time he appeared with counsel, the decision had already been made that he was going to be placed in a second program. Then he left that program, and the moment when the court was made aware of these circumstances was again the first time that he was appearing with counsel before the court.
Was he not interviewed for the program? Did they not do an investigation and an evaluation to make a determination as to exactly what was the proper residential program for him?
Your Honor, that would have been a great question to ask the program at sentencing rather than just imposing sentence. We don't know. It's not in the
Okay, so now back to sentencing now. So at the time of sentencing, there was just some comment made by counsel. It was, just like something like, well, so the court knows he left because of they were not meeting his needs. And that was it. There was nothing else stated by counsel at that time. Is that correct?
Defense counsel said, was asked, do you want to speak? And he said, yes, I don't think that this was all Mr. Kelly's fault. This happened and this happened. And at that point, what would have made sense for the court to do and what this court and the Court of Appeals require the sentencing court to have done is the sentencing court should have turned to task and said, do you know anything about this?
So again, this was the 3rd time. He was given 3 chances. And there was, in addition to leaving the program, he had also sustained a new arrest. Is that correct?
At the time, after he left the first program, 2 arrests, honestly, Your Honor. He picked up 2 arrests. And at the time he pleaded guilty to those, a decision had already been made that he was going to be given another opportunity to participate in a program. I would just note, you know, it was shoplifting and possession of a controlled substance. Those were obvious crimes of addiction.
So back to sentencing now. So the time of sentencing, counsel says, you know, it really wasn't his fault because, you know, the program was not meeting his needs. At that point in time, the counsel said, so based upon that, my client would like a fourth chance, that my client would like now to have a program that actually meets his needs? Or did counsel say, or my client, based upon that, would now like to withdraw his plea?
Counsel did not ask for any of those things, but Outley and Fiamegda, and actually this court's decision in Jimenez, don't require more than what happened here for the court's obligation to inquire to be triggered.
Counsel, isn't it true that here, putting aside the fact that the defendant left the program, there were other conditions that he followed? Like he got rearrested, he didn't return. So it's not just about the program.
Well, Your Honor, I think that this is where the inquiry could have really brought to the surface what all the circumstances were. If he was out on the street committing crimes of addiction because he should have been in a program that could meet his needs.
The conditions that I know them don't separate between crimes and crimes of addiction. It just says you can't get rearrested and convicted.
Well, and as to that, Your Honor, I would turn the court's attention to this court's decision in People versus Feliciano. That was a case where the defendant was participating in a program. The program said to her, we cannot meet your needs, but we will find you another program, stay here. She left the program. A warrant was issued because she had absconded. She was returned involuntarily. And despite all of that, the court still remanded for her to be given another chance at a program. So I think that all...
So counsel, if I'm not mistaken, I think I was the court in that case. Was I not? I was, right? That was years ago.
You were.
I was. And I also recall that what the appellate division said was that the trial judge should have given Ms. Feliciano another chance and found another program for her, directed task to find another program for her. We have entirely different circumstances in this particular case, wherein, again, not to belabor the point, in terms of his leaving the program, sustaining the new arrest, et cetera.
Well, Your Honor, my point is that the court should have conducted some kind of...
No, counsel, I'm glad you made that point. And the thing is, I'm concerned about how the court should have done this, the court should have done that. As my colleague asked, were there any comments or statements made by defense counsel to even elicit those kinds of inquiries? Because you're asking the court to be the mind reader then at that point, as a crystal ball. Yeah, I'm not so sure that I'm concerned about essentially placing the blame on the court, saying they should have done more, without any indication from any counsel that more should have been asked or more should have been done.
Well, I'm certainly not expecting the court to intuit that there might be some...
Well, that's what you're implying. That's what you're trying to tell us.
Well, no, I think that defense counsel's comment that this was not all Mr. Kelly's fault raises the question of whether this was a fair discharge from the program. And I would say that in People versus Outley, the Court of Appeals never said defense counsel must request a hearing or must...
And you're way beyond the red light, but I don't believe in that case, nor did the court say that it was incumbent upon the sentencing judge to then make an inquiry as to what exactly the defendant wanted to do at that point in time.
Well, what Fiamegda said, building on Outley, is that the court has an obligation to ensure that there is a, quote, legitimate basis for the discharge from the program before proceeding to impose sentence. And that's what did not happen here. Fiamegda requires not a hearing, just some sort of informal inquiry, and specifically requires that a record be made by the court explaining what the nature of the inquiry was, what the findings were, and the basis for those findings. And that's what didn't happen here.
Okay.
Thank you.
We'll have a minute for rebuttal. We'll hear from the people.
May it please the court, Diana Lewis for Respondent, the Bronx District Attorney's Office. I'd like to start by making one correction. There was a task evaluation done in this case.
Ask about that, counsel, because it seems to me that they're always done. It doesn't task evaluate every potential client to figure out what their needs are and what services
And that's correct. And evidence of the task evaluation can be found in the plea minutes on page 2.
I thought so, because I thought there was also mental health task, and I thought my recollection was that individuals were always screened to determine whether they needed quote-unquote regular task or mental health task. But to follow up on what your adversary just talked about, the Fiamenta case, my understanding was that that case also said that you don't need a full-blown evidentiary hearing in every case where an individual is discharged from a program. And so, as your adversary mentioned, there has to be something showing that there was, in fact, a violation of the plea agreement in terms of the program. So here we have an individual who left the program on at least 2 occasions, sustained new arrests, did not return to court. So under Fiametta, is that sufficient, or did you still need to have more for the record?
I believe that's sufficient because both defense counsel and task at the sentencing agreed that the defendant left the programs and failed to return to task. And he didn't just fail to he failed to return for weeks. He had sufficient opportunity.
There were warrants ordered on both occasions, weren't there?
Correct. So on that basis alone, the court could have found that alternative, and plus combined with the fact that he had previously failed task in the past, was sufficient for the court to impose the alternative, the jail sentence.
And we're talking about one above the minimum, is that correct? One greater than what the minimum sentence would have been?
That's correct, Your Honor. If the court has no further questions, I'll just ask for an affirmance. Thank you.
Thank you, counsel.
Briefly about the task evaluation. Yes, there was an evaluation done. I think what I meant to convey to the court was that the substance of that evaluation and what Mr. Kelly conveyed to task during that evaluation was not made part of the record. There was, of course, an evaluation done. So just to clarify my position on that. You know, as far as Mr. Kelly leaving and failing to return, that did happen. That is also, as I said, what happened in People versus Feliciano. We are speculating here about what might have been.
I will say that in Feliciano, she left twice, and she didn't come back for a very long period of time. In this case, this defendant left on 3 occasions, right? 2 occasions, and one, he left the very next day. It was like he went in at 11 o'clock and he left at 12. I mean, it was almost immediate that he left, and I think he sustained a new arrest like the next day. So I think it was a little bit more than in Feliciano.
Well, and I think the problem here is just the completely scant record on which the court proceeded to impose sentence. We don't know. Nobody ever asked. Nobody asked him what happened. Nobody asked task what happened at any point in the proceeding. He was just sent to prison. And as far as what the court should have known or what, I guess just my point in conclusion about preservation is even if the court determines that defense counsel saying this is not all his fault does not satisfy the court's instruction in Outley that the court must conduct an inquiry, quote, when an issue is raised, I would ask this court to exercise its interest of justice jurisdiction to hear this claim regardless, just because of the complete lack of any questioning that took place despite the clear mandate in Fiametta that some inquiry must happen and some record must be made. Thank you.
Thank you. Thank you both. The next case for argument is Whitfield versus City of New York. Okay, you may proceed, Mr. Whitfield.
Good afternoon, Your Honors. May it please the court. John D. Whitfield, appellant pro se. The issues in this case are straightforward. The lower court erroneously denied my Article 78 petition, despite the fact there was overwhelming evidence confirming that the two reasons the respondent used for denying me the job was arbitrary, capricious, unreasonable, and unconstitutional, and were apparent pretexts for discrimination. The first reason the respondent used was that it was based on my innocuous protected speech in a 15-year-old award-winning memoir that I wrote entitled The Whitfield Files. And I wrote this memoir to get some public attention on my wrongful conviction for murder caused by police and prosecutorial misconduct. According to the respondent, this protected speech indicated that I was anti-law enforcement, anti-prosecutorial, anti-establishment, etc. And as a result, if I was allowed to work in an ACS detention center, my presence would cause violence, dissension, unease, and instability. As amply demonstrated in my brief, my reply, and in the record, this ground for denying me the job must be reversed because it was based on speculative inferences unsupported by the record. Basically, it was predictions of disruption that was just speculation, based nothing on more than speculation. Also, Your Honors, the lower court's decision must also be reversed pursuant to 3 New York authorities, which are Law Enforcement Union 255 AD 54, 3rd Department, 1999. You have Coral versus Ward, 59 AD 2nd, 286, 3rd Department, 1977, and matter of Coral versus Ward, 46 NY 2nd, 1049, Court of Appeals, 1979. Under the doctrine of stare decisis, my case must be reversed because the facts in my case are similar to the facts in these 3 cases. Indeed.
Mr. Whitfield, you highlight an important fact in this case, which is that this is a very sensitive job. I'm sure you would agree. And that we give a lot of deference to the agency's decision-making on who's suitable for this very difficult, nuanced job. And so that's what you're up against, is the fact that we have to give so much deference to the agency's on-the-ground assessment of people who apply for the job.
Yeah, but if you look at the case law involved in the 3 cases that I'm citing, Your Honor, these cases right here involve cases where it was correction officers who were fired from the job for engaging in Ku Klux Klan and Nazi Germany speech. And these courts concluded that they could not be punished merely because they engaged in that speech without more. There had to be more than just the mere fact of the speech, Your Honor. And I submit to the court, which I have repeatedly cited in my briefs all throughout this proceeding, that there was nothing offensive, harmful, dangerous, hostile, or anything in my speech.
But the agency, the position that you were applying for and what you would be doing would be counseling at-risk youth. And the agency said that their concern was based upon the statements in the award-winning publication, your award-winning publication, that you would be perhaps making these statements to these at-risk young men, and that therefore your statements might cause them to be, that they may be impacted negatively by your statements.
Yeah, but Your Honor, that's based on pure speculation. Number one, Your Honor, I've been doing youth counseling work for a decade. 3 years while incarcerated, 7 years after my incarceration.
Well, that was the other thing, because apparently there was also a concern that even with your background, that your background was not one-on-one. It was group counseling. And this position entailed more one-on-one counseling.
And I submit to you, Your Honor, that is completely false. There is not days that I can go without having one-on-one with children. If you're a youth counselor working on Rikers Island, working with gangs, working in schools, working with after schools, I haven't gone a day without having to have a one-on-one with young folk, because there are certain types of issues you cannot discuss in a group setting. You have to pull these kids to the side and you have to dissect what's actually going on. And with that, I had other issues, but,
You'll have 2 more minutes for rebuttal after the respondent speaks,
Okay,
okay?
thank you,
So
Your
you'll be
Honor.
able to raise a few additional issues then. Thank you very much, Mr. Whitfield. You may proceed.
Thank you, Your Honor. Good afternoon, Your Honors, and may it please the court. I'm Alan Rosinas, representing ACS. Your Honors, Supreme Court's decision in this case was a straightforward application of the deferential Article 78 standard review to a discretionary hiring decision. Let me, excuse me, jump straight to Mr. Whitfield's contention that this decision, the basis for the decision that ACS gave, the bases were pretextual. There were over at least 91 individuals with criminal records who were hired as youth development specialists, one of whom had a manslaughter conviction. This is a position where potentially, maybe rarely.
I mean, in fact, Supreme Court asks you to produce all the applicants to make sure that your determination was not pretextual, right?
That's right, Your Honor. We produced those
It was an in-camera production that you gave to Supreme Court.
Yes, Your Honor.
Right?
And the big point to make here, Your Honors, is that a criminal background in this position can be a good thing if the person has remedied his issues with the law and become a good role model for youths who are still in trouble. So the idea that it was pretextual because we were concerned about his murder conviction is really a tough road for him to climb. There were 3 different affiants here who said, no, it was not about that. It was, we had these other concerns. And the main concern was the Whitfield files. Mr. Whitfield voluntarily submitted it's actually not his entire memoir, but it's the beginning 20 pages or so of his memoir as part of his background check materials. He was not required to submit those materials. He chose to do so. And
Are you implying that if he had not submitted the Whitfield memoirs, that you wouldn't have known about it? I mean, right? If he doesn't mention it, you wouldn't have gone looking for it? Is that what you're trying to tell me?
I mean, Justice Long, I don't want to speculate. I don't know whether we would have looked for it independently.
And then later on, if you had hired him and then later on you found them, then you would have said, oh, he failed to disclose this information to us. But again, why is it not speculative or arbitrary for you to say that simply because Mr. Whitfield has continued his criticism of the criminal justice system based upon what occurred to him, that he would not be able to thrive and be successful in this position or even qualify for the position?
Well, Justice Weber, I think that the concern that ACS had was not so much the content of his views per se, which I don't think ACS took a position on whether it was right or wrong, as the anger and the vitriol that he still had toward law enforcement personnel. And the concern that it had was these are at-risk youths who are regularly interacting with law enforcement personnel, whether it be prosecutors in the context of...
But counsel, that anger or whatever feeling he had towards the criminal justice system was displayed in a writing that was a decade ago. Do you have any information or any reason to believe that he still harbors those same feelings and that he will impart that to any youth that he counsels?
Well, again, Your Honor, he voluntarily submitted this as part of his present application. So I think it was reasonable for ACS to infer that his views were either not very different or were essentially the same.
Why would it simply not be, again, an indication of his background and also the obstacles that he was able to rise above? The obstacles that he encountered and he was able to rise above to be at this position in his life.
Well, Your Honor, I don't think that we take issue with the fact that he's been a successful individual in a number of ways. The question is simply whether or not he's appropriate for this position. Again, as we say in our brief, ACS is looking for credible messengers, and the concern that ACS had was that someone who is still so angry at the system that these youths find themselves within and have to work
Again,
within.
I have to ask, so the still so angry part, you're deducing that from the fact that he submitted this writing and he wasn't required to. Is that correct?
That's right, Your Honor. The question is whether there's a rational basis in the record.
So is there anything during the interview or anything else during the interview process which would lead you to believe that he was still quote unquote angry at the criminal justice system and that he would be imparting this anger to the youth?
I think that the only interview that took place, Your Honor, was the initial interview that resulted in the conditional offer, and there's no evidence in the record either way about what transpired at that interview.
Okay,
We ask that the court affirm. Thank you, Your Honors.
thank you.
Thank you, Your Honor. Briefly, I just want to point out this anger thing, Your Honor. I mean, the memoir, I'm just flabbergasted. Where's the anger for simply just pointing out certain facts? In my interpretation, it was just merely facts. But in any event, I also want to point out something else, Your Honor. This whole issue about Jots Edwards, I believe that we are here today because of ACS employee Jots Edwards. On August 3rd, 2018, ACS employee Jots Edwards assaulted a 6-year-old child in an ACS detention center. And as a result of this assault, ACS Commissioner David Hansel made statements to the media indicating that he created a new hiring protocol that excluded individuals with murder convictions because Mr. Jots Edwards had a murder conviction. At this time, my case was being reviewed by ACS, my criminal background, and miraculously, they hired me, and then miraculously, they don't hire me. I mean, you know, they never explained, according to the Court of Appeals, which makes very clear that when you suddenly change your decision from one level, I think the case is, Tall Tree Constructions Corp. Zoning law, it's a 2001 Court of Appeals case that just says that you have to indicate the reason for reaching a different result on essentially the same facts. That's clearly arbitrary and capricious. And once again, Your Honor, I mean, according to those 3 New York State Court of Appeals cases, it made clear that if you're going to punish someone for protected speech, there has to be more than just speculation.
Mr. Whitfield.
I mean, I've been a youth counselor for 10 straight
Mr.
years.
Whitfield.
I've never had any problem.
Mr. Whitfield, a question is that you're not precluded from applying again in the future for any position that ACS offers. Perhaps this position comes up again. You can put in another application, correct?
I've already applied for the civil service aspect of that and passed that as
okay.
well. So,
Okay.
I mean,
Okay, thank
I'm
you.
a youth counselor, and I've just decided to dedicate my life to saving young lives, use my journey to save those lives, because I believe it's a valid journey. Thank you.
Thank you very much. Thank you both. The next case for oral argument will be Cabrera versus Lincoln Square Condominium in Michigan. Who do you represent?
Your Honor, I represent Lincoln Square Condominium, the owner of the building.
Okay.
Good afternoon, Your Honors.
Good
My name is Joseph Kraft. I represent Lincoln Square. Lincoln Square owned the property at 111 West 67th Street. In the fall of 2013, as they had in the past 6 to 10 years, they hired Creative Christmas Incorporated, an independent contractor, to place holiday lights on the trees around
The contract that you had with Creative provided that Lincoln Square had the responsibility to, quote, provide location to park boom lift during installation and removal, close
That's right.
quote.
It does state that, Your Honor. Now,
You
if
had that duty, so why doesn't that at least give rise to an issue of triable fact about whether you might be responsible for the incident that led to
Well, in this particular case, Your Honor, Creative Christmas leased a boom lift from Altitude. The boom lift was brought to the property. It was maneuvered around the area by employees of Creative Christmas and placed on the night of the occurrence. It was placed against the curb in the parking lane on Columbus Avenue. There's never been an issue with respect to the location of the boom lift. The reason why this accident happened, according to the police, OSHA, the experts retained by UPS, was that plaintiff's decedent moved the basket of the boom lift out and over the driving lane of Columbus Avenue without properly warning the traffic coming, and the tractor-trailer struck not the boom lift, the basket of the boom lift that was in the driving lane of travel.
Why are these not all issues of fact which would be determined by the trier of fact?
Your Honor, there is no, it's a feigned issue of fact with respect to the location of the lift. The lift was in the parking lane. The lift was parked in the parking lane of travel. The lift itself had nothing to do with the happening of the accident. The accident happened because Mr. Salinas, plaintiff's decedent, moved the basket up and out and over the lane of travel.
Is the basket connected to the lift?
It is, Your Honor, of course.
So I don't understand.
Well, the boom...
It's all one apparatus, and you're, under the contract, you were the one who was supposed to direct where the setup would be.
No, we were supposed to provide a location to
Provide a
park the
location.
lift, right?
I
So
apologize.
presumably, Your Honor, if there's parking all along Columbus Avenue and the employees of Creative Christmas had no place to put the lift, perhaps you could argue the contract would be in play. That's not the case here.
Did you submit anything stating that you specifically told them, or you told them not to place it in at that location?
We didn't tell them not to place it there. That was a perfectly fine location.
But it seems that what happened was, even though you're claiming that it was in the parking area, which you feel would have been the appropriate area, in order to reach and maneuver to put the lights in the trees, he had to move the boom, or move the basket back. And shouldn't that have been part of the consideration that you had? Well, you can't just, go direct up. He had to be at an angle, I guess. And this is all part of the determination about how to appropriately place and get the job done.
Your Honor, that was entirely Creative Christmas' job. They are the independent contractor. They had the employees. They had the training. They had the know-how. They were supposed to warn the traffic coming down Columbus Avenue. They were supposed to safeguard this job site. The location of the lift was a feigned issue that unfortunately Judge Getz accepted, and I respectfully submit that he should not have, and summary judgment should be awarded in favor of Lincoln Square.
Okay. Thank you very much. Counsel for UPS.
If it please the court. Tom O'Connor for UPS, and the UPS defendant, driver Robert Kreitzer.
You want to have some water?
I would, thank you.
You don't want to make people really uncomfortable.
Thank you, Your Honor. I think as my counsel just stated, one of the things, the fundamental fact here is not how the UPS has no responsibility for the job site, has no responsibility for all of the egregious actions.
But you had, it was your truck that hit the basket, and you represent the driver of the truck that hit the basket.
That's correct, Your Honor. So Robert Kreitzer is driving on a designated truck route in Manhattan.
Well, how is there not at least an issue of fact, since we know there can be more than one proximate cause of an accident? How is there not at least an issue of fact as to Mr. Kreitzer not seeing what should have been seen as he was making the left turn onto Columbus Avenue, which is what I understand he was doing at the time of this accident?
No, Your Honor, at the time he's driving south on Columbus Avenue.
He was changing lane.
He's in the right, he's changing lane. And
So again, how would that relieve him from any liability, or UPS from liability?
I think, Your Honor, that there becomes in this instance a reasonable standard, which to say is the driver has to see what he's able to see in the roadway.
So how
That's
could he
the
not
standard.
see? How could he not see this? I mean, he would have almost been eye level with the basket, right? With the decedent in the basket, putting the lights on the trees.
Sure, that's not accurate, Your Honor. What happens is the top of his vehicle at least the 10.5 to 11 feet, the top right corner is what comes into contact with the basket as he's approaching the intersection. He's trained, and their expert admits it, as he approaches the intersection, he is trained to study from corner to corner to look for all of those things we look for when we drive in Manhattan. People walking, cars pulling out, pedestrians. We have
So
done.
he's not trained to look up.
He's not trained to look up, Your Honor, in this instance because it's.
So now the decedent's co-worker was also in the basket with him. He testified that the basket was well lit, and so therefore, if it's well lit, although it's up, it would, again, why would your driver not see what there is to be seen?
So, Your Honor, we have done a complete conspicuity study on what occurred on that night. It was not one lit. The lighting,
Sorry,
it was not well lit, Your Honor, at where the basket is. The basket has, in the area of where the accident occurred, is 1 foot candle of power of light. The basket is up there. From a conspicuity point of view, it would be invisible to a driver approaching that lane.
Counsel, doesn't your driver say it was well lit?
What is that, Your Honor?
Your driver said it was well lit.
No, Your Honor, that's a misnomer on what they said before. What my driver testified to is the intersection was well lit. When you look at the conspicuity study that occurs here,
So you're saying that the intersection was well lit, but the basket that was high in the air was not?
was invisible, Your
Okay.
Honor.
Now, let me ask this. I'm looking at the pictures here. The apparatus itself, the boom, it's parked on or stationed on the parking lane, but it extends into the driving lane, doesn't it?
What happens, Your Honor, is the boom extends up. and
No,
then
but
the
I think he's talking about the body of the chassis.
The body, correct.
No, Your Honor, actually, where the body of the entire boom, the actual base of it, is in the parking lane. That covers part of the intersection. And the cones that they've put so much weight into are still in the parking lane also. There is nothing in the driver's lane.
Counsel, I don't know if we can say that as a matter of law. I looked at the same photographs that Justice Rodriguez is looking at, and it does seem to be poking out into the driving lane. That it's wider than an average parked car, in other words, and that the cones are to its right, to its left as you face south on Columbus. So.
Your Honor, that's not accurate because this entire event is on videotape. And if you look at the conspicuity study, you can see that the 3 cones were placed by the expert inside the parking lane. There is nothing in the driver's lane of travel.
Okay, so a jury couldn't possibly draw a different interpretation of the photograph, is what you're saying?
It is a photograph, Your Honor. It is on film where those cones are. They are up against the side of the vehicle, and they are completely encased.
We're not talking about the cones specifically, because you're right. In the photograph that I'm looking here, there appear to be at least 2 cones that are within the parking lane. But if you look at it, the apparatus looks like the front 2 tires of it are extend into the driving lane.
That's not accurate, Your Honor. There is no part of
Photograph is not accurate?
No, the conspicuity study shows that the dimensions of this entire vehicle have been studied. They've been placed into the parking lane. And if you look at the video of this event, Your Honor, nothing extends into the parking lane. There is nothing that would have given this driver any attention that there was a work site going on. And so, I realize my time is done, but I would say to the court that the fundamental problem here is that there is no evidence to the contrary that is admissible.
Okay, thank you. You represent whom?
Plaintiff respondent, Your Honor.
Okay.
Raymond Macera for the plaintiff respondent. May it please the court. As the court pointed out, there's clearly a question of fact as to the negligence of the driver. The boom does stick out. The cones are adjacent to the parked cars in plain view. They're orange. They're clearly 3 of them that would give them at least warning that there's something going on.
What interests me is the statement that the driver is trained to look left, right, down, but not up. Okay, so that's what interests me. Then I think that's for a trier of fact to determine whether or not looking up is something that, well, you should have looked up. I can't think as a matter of law that there's not a factual issue there. I mean, when you're driving, you're looking at all directions.
And truck drivers in particular trained. They have a big vehicle.
Especially these 16-wheelers.
Have to be aware.
Yeah, I've seen a 16-wheeler squeeze through a double parked car like that because they're just so good at going right through.
And that's part of the problem. This driver was very inexperienced. He'd only been doing it for a very short period of time, 2 months.
It was 1:30 in the morning, correct?
Correct.
It would have been interesting to know how long of a shift you've been driving too, right? I don't think that was in the record.
Was there anything in the record as to how he's going down Columbus? Yeah, Columbus goes down. So he's going south on Columbus. How long had he been on Columbus?
He turned off from 110th, I believe.
And so he had been on Columbus since 110th?
Right, he's coming straight down.
Okay, so when you're driving, I recognize they're taught to look in front of them. But I think if you're coming down Columbus, you may also look in front of you and then you're gonna see whether there are trees and booms, et cetera, as you're driving down Columbus.
The truck driving expert, Mr. Roddy, explained the aim high.
Aim high
steering.
means
Supposed to be
steering.
looking
Yeah.
ahead over a block, just for that. That's what truck drivers do. They have to be looking way ahead because
Yeah,
they're
but if
driving
you're
a truck.
just
It's not a
looking down
car.
Columbus at 1:30 in the morning, I would think you're gonna see if there's a boom or whatever in front of you, or blocks down, and then cones as well.
I mean, Columbus Avenue is a busy place,
a
but at
well-lit
1:30
place.
in the
It's-
morning, I mean, there's not that many people.
I think you're gonna see, something further down. Counsel, you're also, are you opposing the granting of summary judgment to Altitude?
No, we have no position on the altitude.
Okay.
With regard to Lincoln Square, contractually and with Creative Christmas, it was clear it was their duty to provide a safe location. The boom was actually not exactly in the lane. It was actually in the crosswalk when it happened.
So when counsel was talking about the study that he did that said, everything was exactly placed right, and Judge Rodriguez thought that was not necessarily the way the picture shows,
I would agree with that. It's not. And the lighting was not the same. They didn't do it at the holiday time. There were already some Christmas lights up. It's clear there were street lights on. The police report says that. There were street lights in the area. We're not talking about a country road. We're talking about East 67th Street in Columbus.
West 67th Street.
West.
You're obviously not from
Yeah, you're not,
Manhattan.
yeah.
It's okay. It's all right.
I
We'll
apologize.
forgive
Okay,
you.
it's West 67th,
West 60.
please. West side is different
Right, West
from
Side,
the
I'm
east side.
sorry. As far as the damages,
You need a
Your Honor,
passport.
Clearly,
And this is in the crosswalk?
this is at the intersection,
At the intersection?
right?
Oh, okay.
So it's clearly well lit. Now, as far as damages, defendants did not make out their burden, as the lower court pointed out, with regard to pecuniary damages and with regard to the children, four
Well, the
different children.
pecuniary damages, I mean, you had affidavits
Yeah,
from
affidavits.
the mothers of the decedent's children saying what he was doing to help support them.
Right.
And even if they say, well, that's self-serving, again, everything is somewhat
And-
self-serving, but they can always, raise that. It's
The
at
defendants
least
had
an issue
reserved
of
their
fact.
right to their deposition, which has been done after this. Depositions have been held, and they've testified under oath. There's a bank record. And with regard to the time frame of conscious pain and suffering, Dr. Pugh has given a formula and explained how he has 4 seconds where he's traveling before he hits his head. Clearly, the autopsy report indicates that the manner of the injury and death was because of hitting his head after his torso hit the ground, then his head hit. Mr. Bacadano was in the same position. He luckily didn't hit his head and is here to tell us about it. And he pointed out the fear and the panic as you're flying through the air after a truck hits you.
And he was right there with them.
The same exact position. So clearly, and the hospital record indicates in several places where he was conscious, stuporous as opposed to being comatose, and where he responded to noxious fumes and responded to pain.
Okay.
Thank you, Your Honor.
Thank you.
The guy in the back.
No, there's another respondent here, right?
Altitude.
Yes. You represent Altitude.
Yes.
So you were granted summary judgment, is that correct?
Yes, Your Honor.
And so, why was that correct?
The lower court, Judge Getz probably granted summary judgment in Altitude's favor. Its role was really limited to renting the lift to Creative Christmas. There was no evidence of any defect in the lift or any maintenance issue that caused the accident. Altitude had rented it to Creative on prior years without incident. Altitude did not supervise, direct, or control Creative's work. It did not have any employees present on the day of the accident. The only party that has opposed my motion is UPS, and I would submit they want to make an equipment rental company basically the insurer of the people it rents to, and I think that's too broad a reading of it. They say we're responsible to ensure that whoever we rent to, that only trained operators use it. We're responsible to ensure its use safety. Well, that's not what, they don't cite any authority for that. And Altitude is entitled to rely on a very extensive contract it had with Creative to make sure that only trained operators use it, that they follow all rules, instructions. It's laid out by Judge Getz in his decision where he goes through all those contract terms, including compliance with OSHA, compliance with federal regulations, being familiar with the operational lift. All those things are laid out in the contract.
And the fact that many of those things may not have been done by Creative Christmas, who defaulted in this case, correct?
Correct.
You say you have no responsibility for that. You didn't have to check up to make sure they were following all the OSHA regulations and all those things?
Correct. It would put too much of a burden on equipment rental companies.
Well, you
We
rented
can have
to them in the
employees at
past,
every
too.
site.
You rented to them in the past without any incident,
That's
right?
correct, Your Honor. There were 5 occasions where they rented the same equipment from us. It was used at the same location, all without incident, which really goes to the negligent entrustment claim. There's no evidence that we acquired any specialized knowledge that this renter, Creative Christmas, would use it dangerously, our equipment.
Any VTL or other regulation which would affect you?
I'm sorry, I didn't hear.
Any VTL or any other regulation which would affect you? I mean, it's not a motor vehicle, so there's no VTL issue there. Anything in terms of the size of it that shouldn't be on the street without lighting or anything?
Yeah, there's no provision that affects it. The VTL, I agree, does not apply. It's not a motor vehicle. It wasn't being used as a motor vehicle at the time of the incident. So I think that clearly doesn't apply. And then just as an end to it, you know, they say it's a motor vehicle, but then they say, oh, you don't get graves too. So I think we just get clearly out on we don't have a duty. There was no evidence of negligent entrustment, and we're not vicariously liable under the VTL 388. And I think just one more point, the Monell case in the Second Department kind of hits on that issue of the VTL. And unless the court has any further questions, I have nothing further to add. I would just ask that the decision be affirmed.
Okay.
Thank you.
Thank you very much, counsel. Okay, you have 1 minute.
1 minute. Your Honor, the same rationale with respect to altitude vis-a-vis Creative Christmas applies with respect to Lincoln Square vis-a-vis Creative Christmas. We did not direct, control, instruct, or supervise the way Creative Christmas did their work. They did work for Lincoln Square for 6 to 10 years before, without incident, without complaint. We were happy with their work. They rented the boom lift. The boom lift was placed in the parking lane. The boom lift was operated and controlled by employees of Creative Christmas. Employees of Creative Christmas were entirely in charge of this job site. Nobody from Lincoln Square was there. They had the opportunity and the responsibility to safeguard the traffic flow to do their job. The parking of the boom lift is a feigned issue of fact, which doesn't defeat summary judgment. Unfortunately, Judge Getz accepted that feigned issue, and for those reasons, Your Honor, we respectfully request that the decision of the Supreme Court be reversed insofar as Lincoln Square is concerned and summary judgment granted. Thank you.
Thank you.
Tom O'Connor for UPS and rebuttal. As described just now, every other litigant or person involved in this case, either party or litigant, was directly responsible for this accident. The construction site was not prepared according to multiple regulations of the city. The plaintiff himself put the basket over the direction of travel of the travel lane. Altitude rented it to a fly-by-night company that as soon as their criminal liability was over, they've never been heard from again in this case. So this entire scenario which is set up here, this entire hazardous and dangerous condition which was set up at 1:30 a.m. in the morning, my clients had no part of. If you watch the videotape of this accident, multiple vehicles drive directly underneath this basket. There's no braking, there's no maneuvering, there's no driver recognizes this construction site or this basket above the travel lane. It is not until a vehicle of a certain height hits the bottom of the basket. And the conspicuity studies show, and so I know there's been some talk, I know my time is up, but I know there's some talk about he should have been able to see this. It was invisible to the driver.
But the thing is, there are other people who are experts and other testimony in this case that does not agree with that. I mean, I understand that's your point, but I also see that there are issues of fact, and I don't think that's our job at this point to make to evaluate the facts.
I think it is, Your Honor, for the simple reason, and in response to the court's question, the simple reason is that the affidavit submitted by Mr. Roddy, their supposed trucking expert, contains no analysis, no measurements, no studies. It doesn't do anything. It makes a conspicuity judgment that this was visible to the driver without any analysis.
Why do you need analysis in this case? Why would it not be the testimony as to what you see or don't see as a driver when you're going southbound on Columbus Avenue?
That's true, Your Honor, because this is a travel route. I would say to the Honor this, that we have done the conspicuity study. We have determined that this basket would have been invisible and the human factors would have shown that the driver wouldn't have seen it, as did the multiple vehicles that traveled right past this location.
So because no other vehicle hit the basket, then therefore, what, your client would not be liable?
Not in the least, Your Honor. Matter of fact, they would be liable to us for putting my driver in a dangerous situation. And when we talked about aiming high, that is a driver technique where you look down the road 10 to 12 seconds. It has nothing to do with the visibility of the height. If I came into this courtroom and I said to this panel, if I said my driver hit a pedestrian at the intersection, and you asked him, why did he hit the pedestrian? And he said, I was checking the trees. You would not listen to that for 1
Counsel, it's
second.
not a binary choice. I don't think that's a strong argument for you.
Yeah.
No, what I would say, though, Judge, is that because there's no conspicuous, the basket was invisible to my driver, he is allowed to do what his job was to do. What would a reasonable driver do approaching the intersection of 67th and Columbus at 1:30 a.m. in the morning? He would be checking the crosswalks. He would be checking for pedestrians, for bicyclists. He would be checking for those dangers that everyone presents on the roadway.
All right, counsel.
Not people up in a tree.
We heard your argument. Thank you very much. Thank you all very much. Appreciate it. The next case have a nice afternoon. The next case is De Silva versus Toll First Avenue. Okay. Okay, there you go. All right, you may proceed. Please let us know who you are and who you represent first.
Thank you, Your Honor. May it please the court, my name is Yolanda Ayala. I represent the toll defendants in this case. It's the defendant's contention that the trial court erred in finding that the plaintiff was entitled to the protections of Section 240 because all of his medical records, accident reports, and testimony of his coworker and casino's principal all revealed that he fell from a height of less than 6 feet. In addition, the plaintiff has never submitted an
Counsel, I don't think that's a strong argument. I wouldn't dwell on that one. We've certainly found that falling from lesser heights has given rise to 240 sub 1 liability. So maybe move on to your next point.
Okay. At minimum, we believe that the trial court should have found there was an issue of fact as to whether the plaintiff's own conduct was the sole proximate cause of the accident. The court tried to say that it was a comparative negligence issue, but the testimony of casino's principal clearly indicates that this Perry system that he was erecting could have been done solely by standing on the floor.
But I mean, I thought he had to put the side pieces in. They were over 6 feet tall. How's he going to stand on the floor and do that?
As my understanding is, you do the first level and then you go up and up.
Well, once it gets up and up to 6 feet, I don't understand how he's supposed to do it standing on the floor.
Well, there was a diagram provided by casino's principal.
I saw that, yes.
Right, that establishes, again, our expert also established that there was no contradicting expert report by plaintiff that was submitted to refute that. And again, the principal said he's done millions of these for many, many years, and there's never been an issue with not erecting it from the floor. So we think at minimum there was a question of fact as to the proximate cause of the accident. In terms of Casino's appeal against me, it's my position that the trial court properly found that Section 200 and common law negligence cannot lie against Toll Brothers. Casino basically references coordination, scheduling, all these general supervisory duties, which this court has repeatedly held does not rise to
But
the level.
you need something more than general supervisory position. You have,
Right. That's our position.
I understand why Casino wants the 200 and the common law back in, because that's the only way you can get the contractual indemnification, right? I mean, if you're out on 200 and common law, then you get an automatic, like I think Supreme Court granted you, summary judgment on your contractual indemnification, because you're only vicariously liable.
Right. So that was exactly my next point on my statement, Your Honor.
I got it. I read it.
So if there's no other questions, I'll rest on my brief. Thank you.
okay, okay, thank you very much. And you represent Casino, correct?
Yes, Your Honor.
Casino. You may proceed.
Thank you. Please the court. Sorry Sober for Casino Development Group Incorporated. We support the toll defendant's arguments as to the grant of 240 for the plaintiff, that it was that there's questions of fact exist, and that the grant was that the trial court erred in granting the plaintiff 240. We would also like to just add to the argument that we believe that the reversal of the trial court's order is appropriate as a matter of law, because there's a question of fact as to whether the plaintiff's accident arose out of a failure of being provided with a safety device, as there's testimony that the height at which, as there's a question of fact as to the height that the plaintiff fell from, there's a question as to whether the plaintiff needed to have been provided with a safety harness. Moving on to...
It's not disputed that he had a safety harness, correct?
Well, if it was properly latched in.
Well, he said there was no way to latch it in, and was there any contrary evidence to that?
Well, the contrary evidence would be that as there's a question of fact as to the height, the plaintiff wouldn't have needed to be latched in. There's also a question as to whether the plaintiff could have been latched in below, if that would have helped.
Now, how could he latch in below when he's going up? I mean, I'm just trying to figure out, he's building up. So why would he latch below if he's going up? You'd want to latch where you're either standing or when you're going to latch one up, because they're building concrete floors as they're going up on this building, correct? Or am I getting it wrong?
Correct, they were going up, but if there was a possibility that being latched in below would have helped.
Well, if you're latched in below it and you fall, it's not going to help you.
Well, I would argue that if you're latched in below, it could stop the fall, depending on where the latch is latched in below. But
okay.
Moving on to our second point, as to the 200 issue, we would also allege that there's the trial court erred in this decision on granting toll summary judgment on labor law 200, because there's question of fact as to the level of control that the toll defendants had on the injury-producing activity. They had two site safety supervisors. One of the site safety supervisors, who was present every day, who was tasked with not just a mere supervisory role, but he was also tasked with specifically ensuring that all the work performed at the site complied with the applicable OSHA and New York requirements.
That's a more general supervisory safety kind of a position, as opposed to having the authority to actually exercise supervisory control over the injury-producing work. Didn't the plaintiff testify that he got his directions, his orders from his company? They didn't get any orders from Toll. They didn't have anything to do with directing how the work was done.
Yes, that's what the plaintiff testified. However, there's also testimony from Toll's representative that one of the site safety supervisors, Mr. Hersig, had the specific power to stop all of the work and to supervise the site daily as to the workers properly adhering to OSHA requirements. The plank that the plaintiff was standing on when he fell was specifically called an OSHA plank. It was governed, the plank that was put up that he was standing on was governed by OSHA. This therefore falls directly into Toll's site safety supervisor's purview,
Well,
and
for me, the way to look at it is that, you know, you have a subcontract with Toll Brothers, correct? You guys had a contract with them?
I'm sorry, Your Honor.
You had a contract with them, right?
Yes, Your Honor.
Right, so what does the contractual language say about, in terms of who's supervising whom? Right, I mean, I was kind of looking at that, I didn't see it.
Yes, Your Honor. I would say, regardless of what the contract says as to who's supervising who, Toll's representative was present to supervise the workspace on behalf of Toll.
Okay.
Thank you, Your Honor.
Thank you. You represent the plaintiff, correct?
Yes, Your Honor.
Okay.
May it please the court, Lisa Como for the plaintiff's respondents. With respect to this sole proximate cause issue, it's absolutely undisputed in this record that, number one, the top of the post that the plaintiff had to reach was 6 feet 10 inches tall. Clearly, that cannot be reached by a 5'9" worker standing on the ground who'd actually like to see what he's doing. In addition to that, what their experts seemed to be saying or suggesting was that a better way of doing that might have been to put caps on before you erected a portion of the Perry system. I'm not sure how that explains how you could also then attach the other beams that have to go across, which is what he was doing. But be that as it may, it's undisputed that plaintiff was doing what he was instructed to do. He was doing what the means and methods of the work were dictated by his employer. It was the custom and practice. There's absolutely no dispute about that. He was doing what they all did, and that involved having to elevate himself. They call it the OSHA planks. It just means it's a wooden plank of a certain specification. The planks were unsecured. No expert testimony is necessary when you have a case.
What about counsel said something about that there was testimony from, I guess, from her expert that said that the normal way of doing this would be from the floor and not using a plank to walk across, which I didn't I didn't understand, just like you didn't understand. I mean, how could you reach the 6.9, 6 feet 10 inches if you're doing it on the ground? So right. I mean,
right. That's
who
exactly.
does it on the ground? I mean, that's
right. What I took from that, my best understanding of what the expert was saying is that he seemed to think, well, okay, if you put the end caps on the vertical posts while they're on the ground before you erect them, that would be better. But the point is, it's like a V or a W-shaped bracket that's at the end of those vertical poles, and plaintiff has to lay something now into it. He has to secure them, and then something else is going to be laid across it. Clearly, that cannot be done on the ground when it has to be erected at a height of 6'10".
Was there testimony? I thought your adversary had also stated that he had done it like this in the past. He had done it from the ground in the past.
I think the expert was saying that he had done it that way.
The expert?
That was my understanding of counsel's argument. There was no testimony by anybody at the scene involved in the actual work that was the case. Everybody said this was how we did it. We laid a plank across because there were no scaffolds, and that's in plaintiff's testimony, his coworker, Mr. San Pedro, that there should have been maybe a small scaffold would have been suitable. But this is one of the, counsel also pointed out, counsel Fultrell pointed out that, well, plaintiff didn't come back with an expert affidavit in response to what our expert said. But when you have a situation where there are no safety devices provided, there's no scaffold, there's not even a ladder, he had a harness, but it's also undisputed on this record. There's no anchor point. There's nothing above him because you're building a building. There are things you can do in those situations. They have equipment that can give you an anchor point, but that's not this case. That was not happening here. So there's absolutely no dispute that he had no anchor point, he had no equipment. The law is very clear, and the Court of Appeals, I think, has been very clear that when there is a complete absence of safety equipment, this is not like a battle between the experts as to what was feasible or what could have been provided. A little scaffold would have done the job, and they didn't have it, and Casino knew they didn't have it, and that's the way they were made to work, and that's how they did work, by following instructions. A plaintiff can't be the sole proximate cause of an accident or a recalcitrant worker for following his supervisor's instructions in a case like this. So we would ask the court to affirm the order appealed from. Thank you.
Thank you. Counsel, you have 2 minutes.
To answer Your Honor's question, I had said that my expert said it could be done by the floor, and casino's principal, the owner, he also said it could be done by the floor, and he provided the diagram. In response to Your Honor's question in terms of who agreed to supervise who, casino had their own manager, site safety manager, specifically tasked on checking how this was going up. So it was casino, and as the plaintiff's counsel just mentioned, this is a means and methods case. This is not a condition on the property case, and therefore the court found correctly that we're entitled to contractual indemnification. Thank you.
Thank you. Any other?
To the point that Counsel Vertol just made as to casinos' need to supervise the work being done, that doesn't get rid of the fact that exists a question of fact as to the level of toll's control over the injury-producing activity, which was these planks that the plaintiff was walking on when he fell. That there is a question of fact raised by the fact and the testimony showing that toll did have an independent and their own site safety supervisor present daily at the work site, who gave the introductory safety conferences, who was there to specifically ensure that rules and regulations, including OSHA, were complied with. That therefore this question of fact shows that the trial court erred in its decision in granting toll summary judgment on the Labor Law 200 issue, and as Your Honor properly brought up, because the grant of Labor Law 200 to toll was improperly given, or sorry, the court erred in granting Labor Law 200. Therefore, the grant of contractual indemnity should also be reversed.
Okay, thank you very much. Thank you all. People versus Kevin Pantaleone. Okay, you may proceed. I think we're also, we are also aware of the fact that there was a motion that was made, I believe, just at the beginning of this week, yesterday maybe, relating to enlarging the record. So that's basically before us, too. We are aware of that. So you can make your argument accordingly.
Thank you, Your Honors. Good afternoon. My name is Elizabeth Caldwell, and I represent Mr. Kevin Pantaleone. May it please the Court. Mr. Pantaleone has shown over the past approximately 7 years when this case began that he is capable of addressing his addiction and mental health problems that drove these youthful offenses. At the same time, he's furthered his education, he's excelled at work, and found success while on post-release supervision for the last 17 months.
Counsel, how was the waiver in this matter defective?
Yes, Your Honor. There are 2 reasons that the waiver is defective here. First, even assuming that there was a waiver required by the written plea agreement, the court's colloquy with Mr. Pantaleone did not adequately apprise him of the fundamental rights that he was giving up. For one, the court explained that normally appellate counsel and poor persons relief would be available to Mr. Pantaleone on appeal, but never specified that that would be true regardless of any waiver. So there was an implication that he would have already, or that those things would not be available to him. Additionally, the court said simply that some claims would be reviewable despite an appellate waiver without specifying what claims those were. And while it's not required for the court to specify every single thing that survives an appeal waiver, the underlying documents here did not adequately explain that to Mr. Pantaleone. If you actually look at the appeal waiver, the written appeal waivers that were signed, it specifies claims that survive an appeal waiver. including that he could continue to raise a claim about his constitutional speedy trial rights. If you actually look at the plea agreement itself, it says the exact opposite. In paragraph 5 of the written plea agreement, it says that he waives that right to appeal as part of his appeal waiver. So we have a colloquy that doesn't specify what rights remain as a result of the appeal waiver, and we don't have anything else in the record that would have let Mr. Pantaleon understand that himself. And I think that's particularly troubling here because we have someone who is 20 years old at the time that he entered into this plea agreement. He has virtually no experience in the criminal justice system.
That may be true, counsel, but isn't it a fair statement to say that the court here went through great lengths to give him more opportunities than most courts would give most defendants? There were violations after violation of the agreement. This is a mental health repleader, and the court gave him ample opportunity. Why should we change what happened?
Your Honor, Mr. Pantaleon did have some relapses in the course of his treatment, and the record shows that he diligently continued to engage despite those problems. And he went through successfully a year of outpatient addiction treatment, 6 months.
Given his history of issues, mental health, and also I think he tested positive, I think I counted 5 times. I might be incorrect with the number of positive tests. Given all of that, isn't he a prime candidate for post-release supervision for the 5 years of post-release supervision because he does need that supervision?
Your Honor, 5 years post-release supervision is not necessary in Mr. Pantaleon's case.
You want 2.5 years. He's already been on post-release supervision for, 18 months?
Yes, Your Honor.
So we're talking about another year.
Correct.
On post-release supervision. But again, would that be a sufficient period of time to ensure that he, again, has the proper amount of supervision and guidance in his life? Because as you said, right now he's 20-something years of age?
That's right, Your Honor. He's almost 27. Your Honor, yes, I do believe 1 more year of post-release supervision is sufficient here. We have the times that Mr. Pantaleon relapsed, which he did, and he took responsibility for, if I may finish. He was 21 and 22 at the time. He's now almost 27, and we have, as I've documented in the motion to expand the appellate record, since his release, he has completed all of the drug treatment that he was required to as part of post-release supervision last December. He has continued to find success. He's found a job. He's been promoted 3 times within that job. So this is someone who has shown that he can outgrow his past. He has newfound maturity, and he's at a different stage of his life. So I think that 1 more year of post-release supervision, if the court reduced his post-release supervision to the minimum, is sufficient to guarantee that he can move on with his life and put these incidents in the past. Thank you, Your Honors.
Thank you.
Good afternoon, Your Honors. Jeannie Campbell-Urban for the people. The first thing that I would like to do today is alert the court to a change in the law which will affect...
The less is more.
That's exactly right, Your Honor. It was passed after briefing was completed in this case on, I think it was September 17th of this year. It does not go into effect until March, but once it does go into effect, it does a couple of things that the people believe...
It's a substantial change in the law and the PRS.
Absolutely, and it directly addresses many of the concerns that the defendant raised in his brief.
The technical violations are no longer sufficient to put somebody back in incarceration, which is, I think, the statute is correct.
That's right. I think is particularly relevant to this case is I think, my understanding is that I believe positive drug tests, as long as it's not connected to a DWI case, that type of technical violation will no longer result in incarceration ever. Other technical violations, there's going to be a sliding scale. The first and second technical violation cannot result in incarceration. You have to get up to, I think it's 5 technical violations before you're looking at 30 days, which is the maximum you can ever get for a technical violation. The other important aspect of the Less is More Act with respect to Mr. Pantaleon's case is the good time credit that it, the mechanism that it imposes. So once the law takes effect, for every 30 days that the defendant is in compliance with the conditions of his PRS, he will have 30 days taken off of the time that he has to be on PRS. So if it's true that the defendant is going to continue to do well, is not going to commit other crimes like the residential burglaries in this case, and is not going to relapse again, then he will be able to work off his PRS without this court having to do anything. The legislature has allowed for that mechanism to take effect. So that's the most important thing I really have to say to you is that the law has changed significantly since briefing was completed in this case. Just quickly with respect to the terms
Essentially becoming less punitive and more really encouraging the individual to really, to get where you got to go, I guess, in a sense.
I agree with that characterization. I think the goal is that PRS is still meant to be supportive for defendants who are reentering society, still, helping them find the appropriate programming, et cetera. But to the extent that they violate the conditions, there is, I think, a lot more due process now and just a lot less punishment, at least with respect to certain technical violations. There's no incarceration anymore that's even possible. I do just want to emphasize, as this court mentioned in its conversation with my adversary, how compassionate and how fair the mental health court was with this defendant, gave him numerous chances to complete the programming.
I think even the judge, during the sentencing, acknowledged, he said, this is a very hard case for me because I really like you.
Yes, he said that, I think, both when he remanded the defendant a month before the sentence and actually on the date of the sentence itself. And I think that's clear also just from the record, the numerous chances that the defendant was offered more programming for each relapse up until the point where he literally brought a bottle of someone else's urine to the courthouse in an attempt to cheat the court-mandated drug test. So the court did everything in its power to help the defendant successfully complete the mental health court program. Unfortunately, that isn't what happened, but the defendant still received the promised alternative sentence of 5 years in prison and 5 years of post-release supervision. That was a significant departure down from the overall exposure that he faced if he were, to have gone to trial and been convicted. I see that I'm out of time. I will just say that with respect to the waiver issue, because I know Your Honor asked my adversary, the court's colloquy was extremely thorough. The court was well aware of Mr. Pantaleon's mental health issues at the time that he took the plea. He was very careful to carefully explain all of the terms. And for those reasons and the reasons in our brief, I'd ask that you please affirm. Thank you.
Thank you very much. All right, Counselor, you have a minute.
Thank you, Your Honors. I would like to begin just with the passage of less is more. While we, of course, welcome that change in the law, that doesn't alter the fact that Mr. Pantaleon right now is subjected to unnecessary and punitive post-release supervision that the district attorney's office has acknowledged. It's a very harsh punishment. And my understanding is that the change in the law with respect to the good time credit has not yet gone into effect. So I don't believe that is operating yet in Mr. Pantaleon's advantage. In terms of the court's compassion for Mr. Pantaleon, of course, Mr. Pantaleon did benefit from the court allowing him to continue his engagement with the program. But Mr. Pantaleon should not be subjected to the 5-year PRS term solely for that reason. We have here someone who was deeply, if I may finish just my sentence.
Sure.
Mr. Pantaleon was very humble before the court. He apologized when he made mistakes, and he engaged genuinely with it. And for that reason, and all the other reasons stated in our briefs, we ask you to reduce his sentence to the minimum. Thank you very much.
Thank you. Thank you both. The next case is Jason Frazier and Cynthia Bryan. You may begin. Good afternoon.
Good afternoon. May it please the court, my name is Mercedes Maldonado with Karasik and Michella, representing Jason Frazier. If the lower court decision is upheld, it would eviscerate the integrity of the written contract between Mr. Frazier and the Department of Corrections. Under that agreement, Mr. Frazier agreed to a limited probationary period limited to sick leave violations. The department holds him in violation of its out-of-residence rule. And the department has certain requirements that it must follow before it's at liberty to conclude and hold him as being out of residence.
So you have to, the inspector went to Mr. Frazier's home. He knocked on, the inspector went to Mr. Frazier's home. He knocked on the door 20 times. He stated that he did not see, he rang the doorbell 20 times. He also knocked on the door 20 times. And he called Mr. Frazier's phone, right?
Correct.
And additionally, he said he saw no lights on and heard no noise within the residence. So from my understanding from the briefs is the fact that the rules require that the inspector call the individual and allow it to ring 20 times. Is that correct?
That's correct, for a total of 40 times.
For a total of 40 times, 40 rings. But in this instance, apparently because of voicemail, after the 7th ring, it would go directly to voicemail.
That's what the department claims happened here, but
And they claim that they called twice. So the first time, 7th ring, it went to voicemail. And then the second time they call, again, it goes to voicemail. And so your position is that they should have continued to call until you had 40 rings?
Exactly, Your Honor. The directive is clear that it's a minimum of 40 rings, and a minimum is mentioned twice in the directive. It's not a suggestion, it's a mandate.
Is there anything in the directive that talks about the number of times you have to call?
Not as a minimum requirement. It describes 2 calls, but it's not a ceiling and it's not a floor, whereas the 40 rings is a minimum requirement.
And so would that not be a technical violation?
So if you look at Tankard versus Abate, which is a First Department decision involving very analogous facts. There was a probationary employee who entered into an NPA limited to violations of sick leave rules. In that case, the violation was that the employee missed his appointment with the DOC's Health Management Division. He was at work all day. And the Appellate Division said, well, I'm sorry, he didn't make his appointment. So technically, he violated a sick leave rule because he showed up at work instead of at their Health Management Division. That same strict construction of the rules cuts in Mr. Frazier's favor here. The department can't breach a little bit, and that's basically its defense.
So, counsel, the purpose of the rule is to ensure that the correction officer is at home, right?
Correct.
So you're telling us that those additional, 26 rings would have changed that? There's all this evidence he wasn't there.
It absolutely could have. Those 3 requirements, knocking on the door.
They were all complied with except the 24 rings we're talking about, right? 26 rings that you're saying were lacking. And that's going to change the outcome?
Absolutely it could, because you could have an employee sleeping. How many times have you been asleep and the phone is ringing and it becomes part of your dream until it doesn't?
Oh, okay.
And so 40 times is going to wake you up? The additional 26 times would have woken him up? Although the 20 times that they rang the bell, the 20 times they banged on the door, those additional 26 rings would have woken him up. And again, we're not talking about in succession, which is the other thing. We're talking about 7, then 7, then 7, then 7. So I see it.
I would also add,
why it's not a technical violation.
The doorbell was inaudible. It was not working, and the investigator notes that. And that makes the phone rings even more of an imperative.
Okay, we'll hear from the respondent, and then you'll have the minute to
Good afternoon, Your Honors. May it please the court, my name is Elizabeth Friedman, and I am appearing for the respondents. Your Honor, the court below properly dismissed this proceeding and properly found that the regulations had not been violated here. The court carefully looked at what the investigator did, carefully looked at the worksheet. Captain Merrill, during his absence control visit, he found no lights were visible, no noise was heard from inside. He rang the doorbell 20 times, although it wasn't audible from where he stood outside the residence. He knocked on the door 20 times. He also called the telephone twice, which is what the regulation 7509 requires. Called it twice, and the phone went into voicemail.
Right, but the regulations say 40 rings, right?
The regulations say you ring the
20
phone
rings the first, yeah,
20
rings.
times, hang up, redial,
20
and
times.
call again for 20 rings. It talks about 2 rings, 2 dialing twice. It doesn't
But it
talk
also
about.
talks about 20 rings. I mean, so is that just a technical violation that we are allowed to put aside?
In this case, the investigator did call twice, which is what the regulation requires. So even if it is.
But doesn't it say call twice, 20 rings each? It requires both of those parts. So he did do it twice, but because of the answering machine or whatever, the voicemail, it didn't ring. So should he have had to do it another few times to make sure he got in the 2 rings, at least 2 calls, plus at least 20?
No, Your Honor, because the regulation doesn't require that. And in fact, the petitioner doesn't dispute that the phone picked up after 7 rings and went into voicemail. And nor does the petitioner allege that there was anything wrong with the telephone. So the fact that it went into voicemail, that is not the investigator's fault. The investigator took all the steps that he could, under the circumstances, to comply with the regulation. He was there for 15 minutes. And in fact, I'd like to point out that when the petitioner appealed the charges, and he wrote an appeal memorandum stating that his doorbell didn't work and that he didn't hear the doorbell. He did not state that he was asleep, and he also did not address the fact that the phone had rung. He said he missed the calls from the investigator, the telephone calls. But basically, that particular appeal of the suspension that he was challenging the charges just basically referred to the doorbell that he claimed was inaudible and that he couldn't hear the doorbell ringing. So in this case, as the court found, Supreme Court found that the investigator took all the steps that he possibly could to comply with the regulation. And the fact that the voicemail kicked in after 7 rings is not something that the investigator had any control over. And I'd like to emphasize that the regulation does provide for 2 telephone calls. Certainly, the investigator did that. Certainly, the investigator complied.
What about Tankard v. Tankard v. Abate?
Your Honor, in that case actually supports our position because there, the petitioner in Tankard, he conceded that he violated the DOC directives and the negotiated plea agreement. And this court found that provided the predicate for the discharge there. In this case, however, there was compliance. Here there was, the investigator called, that case does not, it talks about compliance with the negotiated plea agreement, but here there was compliance with the negotiated plea agreement. And as the court found, that there were nothing illegal in the termination based upon the probationary term of this petitioner's plea agreement. And in fact, the court properly found that all applicable procedures were followed here, and that finding should be affirmed. Thank you, Your Honor.
Thank you.
Again, going back to Tankard, if I may, there the petitioner conceded that he violated a sick leave rule. There's no such concession here. The petitioner maintained that he was home. These procedural safeguards and the type of outreach, the 3 different types of outreach are all put in place so that DOC is only at liberty of saying that you're out of residence when you don't answer, when they've followed all of these steps. Here, there's an admission that it rang, DOC rang the bell 14 times, which is 35% of the total rings that they were required.
The petitioner admitted that he was home, but that he didn't hear the doorbell?
Yeah, in the statement that he wrote in response to the piece of paper left, he said he was home. And he said he tested his doorbell found that it was in fact inaudible, which is exactly what the investigator reported as well. So he lost out on that. But even so, if DOC did everything it was supposed to do, they would be at liberty of terminating him. They didn't do everything they were supposed to do.
Okay.
Thank you, Your
Thank you.
Honors.
Thank you both. Rodriguez versus Milton Barone.
Good afternoon, Your Honors. Joel Celso, on behalf of the plaintiff appellant, Julio Rodriguez. May it please the court. Your Honors, the sole issue to be determined on this appeal is whether the replacement of a broken and inoperable hardwired smoke detector affixed to the ceiling of a building constitutes a repair that's covered by Labor Law Section 240, or whether it constitutes routine maintenance, which is not. The Supreme Court in this case erred by determining as a matter of law that act does not constitute a repair covered by Labor Law 240, but is in fact routine maintenance.
So why is this not routine maintenance?
There's a couple of reasons this isn't routine maintenance. First is the court has generally applied two dispositive criteria for making that determination, and they've almost universally said that something is a repair based on the finding of those two criteria. First is whether the building item has malfunctioned and is inoperable. In this case, it was undisputed. There were only two witnesses who testified, but it was undisputed that the smoke detector at issue had malfunctioned and was inoperable.
So hold on a second, but you're missing a fact here. You had two separate, you had a smoke detector and a CO detector, correct?
That is correct, Your Honor. So there was
They were going to be, both of them were going to be combined into a singular hardwired detector that would detect smoke and carbon monoxide.
That is correct.
That's kind of not routine maintenance, right?
No, I don't think so, Your Honor.
Like you're doing something different now, right?
The reason being, the reason I don't think that that's dispositive of the issue is that, yes, you had a battery op.
I thought that was kind of helpful for you, but if you don't think that's helpful, okay. Okay, that's all right, fine.
Well, I mean, it is helpful, but the reality is, as the plaintiff testified, was that if the hardwired electronic smoke detector had not malfunctioned and been inoperable, so if the only issue that day had been the battery was removed from the carbon monoxide detector, he would not have been performing the replacement. So he testified unequivocally that it was the fact that it was malfunctioning and inoperable that caused him to perform the replacement. And the second factor is, was the entire unit itself being replaced, or were component parts within that unit being replaced? And in this case, there's no question that the entire unit was being replaced.
Was the unit different in kind, the replacement unit?
It was different in kind in that it contained both the carbon monoxide detector and the smoke detector. That's the only real difference that can be picked up from the testimony of the witnesses.
And it's supposed to be hardwired.
And it was hardwired, Your Honor.
All right.
So the plaintiff testified that what precisely was involved in this replacement involved going to an adjacent room, going to the electrical box that contained the breakers, shutting off the breakers for the room, taking the ladder, going, and this was after he'd already tested to verify that the item was broken and had malfunctioned. He then goes to the room, he unhooks the cap of the existing smoke detector in the ceiling, and then he has to unscrew the base of that, which is affixed into the ceiling, and it's actually inset. And then he had to disconnect the wires, which were connected to the electrical hardwiring of the building itself. And he said that involved taking off the electrical caps, undoing the wires, and undoing electrical tape that was wound over those wires. He also testified that in order to do it, he had to be trained by his boss, an individual named Oscar Calderon, in the electrical work, and that his boss was a certified electrician. Now, that process is essentially repeated in order to install the new unit, which is when the accident happens, the ladder shifts, and he falls. The courts have basically said when they're talking about things that fall outside of the purview on a repair analysis, that the analogy that they typically use to say this falls outside of the repair analysis is it's equivalent to changing a light bulb. What they have said very clearly is that if you're going to be replacing a light fixture, that falls within the realm of the labor law as a repair. What I would present to this court and what our argument would be, given the details of what's involved with the replacement of that detector, it's far more equivalent to changing a light fixture, like the Piccione case that we cited in our brief, than it is to just simply unscrewing and screwing in a new light bulb. Thank you, Your Honor.
Okay, thank you. You'll have 1 minute for rebuttal.
Good afternoon, Your Honors. Thank you for the time. I know it's late. My name is Ed Guardaro. If Your Honors, please. To address Justice Owing's comment, the other detector was never touched. This is just one unit, whether it was combining or adding, it was just one unit. It was screwed in. The testimony from the plaintiff is not that he took down the base plate. On page 215 specifically, he says he did not replace any wires. He says, quote, "Those wires don't get touched." That's on page 215. So Mr. Sarath, I'll call him, testified as a witness that while he wasn't looking when the plaintiff fell, he specifically stated that it's a plug-and-play operation. The wires from the base plate get plugged into the new device, the new smoke detector combination, and it just gets screwed back on.
But don't you have to have some knowledge and expertise in terms of what wire goes where?
According to Mr. Sarath's testimony, no. It's literally plugging it in like you would, and he said this repeatedly in the testimony, like plugging in your cell phone or plugging in a power cord to your laptop. You don't need anything. It only goes in one way.
So why is it required that you turn off why was it required that you turn off the power if you're just plugging in your cell phone?
Your Honor, the plaintiff testified that he turned off the power. Mr. Sarath said, no, he never turned off the power. You don't have to turn off the power. In fact, there's a large discussion in Mr. Sarath's testimony where counsel for the plaintiff repeatedly asks him, you know, what are you talking about? You don't turn off the power.
And Mr. Sarath is there the entire time when this is going on?
Mr. Sarath was there the entire time. When the plaintiff fell, he was on the cell phone. Mr. Sarath was on the cell phone, and he looked away for a moment, and that is when the plaintiff fell. But he was there the whole time. And he actually, because of the importance of fire detection, he was with the plaintiff the whole time and every day when they replaced these units. He was always there with him. So that's not the issue. The issue is, what did he do? He simply, literally, I think we've all can use our common sense here. In these particular instances, in these particular facts, he reached up and he had to unhitch the old one, disconnect it from the plug, go down the ladder, pick up a new, you know, he said, the plaintiff testified he threw it in to the basket. He picked up another one, and he literally plugged it in.
Hold on a second. The new device that he put in is a smoke detector and carbon monoxide detector combined. The new one he's putting in, correct?
Yes.
The old one he's taken out is just a smoke detector, correct?
Correct.
And you're telling me that there's testimony that says, because I know exactly what you're talking about, that all you got to do is take the device off and then unplug it and then put the device back on and plug it back in. That, to me, that sounds very odd, because if you're replacing a smoke detector device that's hardwired versus a combined unit, those plugs are not going to be there. That's a little different there. I mean, I got to look at the testimony again, but that's not, you're doing apples and oranges. It's not like a smoke detector, a carbon monoxide detector combined. You're replacing the same one, which I've done it, where you can unplug and plug it back in. You're talking about taking a smoke detector down and then replacing it with a carbon monoxide smoke detector. Those are two different devices.
If I may, Your Honor.
I got to look at the record again on that one.
Mr. Sarath's testimony is that they're made, the manufacturer's KID, K-I-D-D-E.
Yeah.
And they fit within the same framework. They're the same.
No, I'm not talking about that. I'm talking about what you're testifying to, the unplugging and plugging.
Right.
I'm talking about that.
Right.
But Sarath is the one he's not doing the work. Mr.
Correct.
Rodriguez is the one who's actually doing the work. So it's his testimony in terms of what he had to do and what it entailed. And he specifically testifies as to the hardwiring of a new dual smoke and carbon monoxide detector into the ceiling wires.
If Your Honor, if I may finish, if you look at page 215 of the testimony, he specifically says those wires don't get touched. Thank you, Your Honor.
Okay, thank you. Counselor, you have 1 minute.
Just briefly, Your Honor, I'll just address a couple of the things that were.
Could you address that last thing that he said? I mean, what happened? What did he do with those wires?
Certainly, certainly. So what he was asked, if you look at, and I don't know if the page number off the top of my head that counsel's referring to, but what he was asked was if the wires in the ceiling were replaced, and he said those wires don't get touched.
Who said that? The plaintiff?
The plaintiff.
Okay.
Now, if you look at page 214 of the very same testimony, which is this page I do know, the plaintiff does testify in detail about both the removal of the top cap and the base plate and how the wiring for the base plate of the new unit attaches to the wiring of the building. And it's actually all through the transcript, so there's really no need for me to belabor that point.
What about Surratt stating that none of this was necessary in order to accomplish?
Yes, so Sarath, I'm not sure that he was in the room the entire time. I would have to check the record again on that, but it is undisputed that he was on the cell phone, and I actually conducted the deposition, and when he was questioned specifically about what his knowledge was regarding the replacement, he testified he'd never done one, and his only knowledge was based on observations of the plaintiff. And again, he's on his phone, he may be in the room for some period of time, may not be in the room for some period of time. This testimony, I don't think, creates a dispute of material fact. Notwithstanding, if that testimony were fully credited, I still think it would be error for the court to say as a matter of law, because the court has to consider the plaintiff's testimony. But so for the court to say as a matter of law, this is routine maintenance and not a repair, it almost, I think, has to discredit the plaintiff's testimony. So our position would be, at the very, ideally, that be reversed and the plaintiff be granted judgment as a matter of law on 240, but alternatively, that at least it be considered a factual dispute to be determined by the trier of fact. Thank you.
Thank you. Thank you both very much. And last, North American Elite versus Space Needle.
Good afternoon, Your Honors. Aidan McCormack, counsel for North America. May it please the court, may I start by saying thank you for granting oral argument in this matter. We do appreciate it. As I believe you know, this is a contract case, and I thought one of the things we should do is start by looking at the words in the contract. The critical provision that the parties are disputing over is a choice of law and forum clause. That clause contains three, I think, critical elements that should be enforced. First, it states that this contract will be enforced without regard to conflict of law rules. Second, it states that the parties irrevocably submit to the exclusive jurisdiction of the courts of New York.
Counsel,
Yes, sir.
we read all the record here. Let me ask you a question. Your client is a New Hampshire insurance
correct,
company?
Your Honor.
And in order to issue a policy in Washington State, you had to get permission to do that?
Certain contracts, you have to be licensed in the state, Your Honor.
But you didn't answer my question. For you to issue this policy, did you have to get permission to do that?
For this policy, we did have to be licensed in the state of Washington.
So you had to, therefore, you had to comply with whatever Washington state law has or has on the books with respect to issuing insurance policies.
We respectfully disagree, Your Honor.
Why?
Because the Washington state laws don't apply to the question of the interpretation of this contract.
No, you're not, that may be true, that may be the argument, but if Washington state allows you, permits you to underwrite a policy in Washington state for this policy,
yes,
arguably you'd have to comply with their laws, correct, or their regulations.
That's right, Your Honor.
Right.
North
And
American.
one of the regulations, I thought, and correct me if I'm wrong, says that you can't have a forum selection clause that has a forum outside of Washington state.
Your Honor, that is correct.
Okay.
And North American is licensed in many states.
Correct.
And each
And
state
every
has
state has their regulations.
their own regulations.
Like New York has their regulations, you know, South Dakota has their
That's
regulations.
right.
You got to follow them.
That's right. And in order to get contract certainty here, what the parties agreed to, remember, these are sophisticated parties who
Correct.
negotiated a very
Oh,
complex
I'm
deal.
glad you mentioned that. This contract, this policy of insurance, was it a brand-new policy of insurance that you guys drew up between you, or was this a form policy that you had already on the books?
This policy was negotiated between the parties. This is not the only year that they negotiated it. It was a $160 million limit between two very commercially
It's
sophisticated.
not, but it's not a form policy? These
No,
are not
Your Honor.
standard provisions in your policies that you issue to 50 states?
I don't want to mislead you. I am sure there are sections of the policy that you could find in other policies.
Okay.
But
And,
there,
and
there-
one of them would be the form selection clause policy. I mean, that's in all your policies, yes?
It is not in all North American policies, but it is a provision that's extremely important to North American.
Yeah.
I do know of some situations where they have been asked to remove it from, and they've negotiated. But that affects the pricing significantly.
So do you select New York in all of your policies?
We always seek New York law and form. North American, as you may know, is on 6th Avenue and 52nd Street. That's their big office in New York. So that is important to them. New York is a relatively even-handed jurisdiction in enforcing contracts, so North American seeks to have that provision. But the contracts are all negotiated. You don't buy a $160 million insurance company, you know, online.
Contracts may be negotiated, but if they're contrary to law, they're no good. You can't contract something that's against the law, right? I mean, that's contract 101.
That's correct, Your Honor. But the question is, what law? The Washington court has deferred to you. This is a procedural matter over Dovin in all your cases. Madden, ABB.
Well, I'm glad you mentioned that, because you know what this case is? This case procedurally is at a preliminary injunction phase. Those arguments that you're raising, don't you think would be more appropriate to a motion to dismiss, which I think the trial court below was trying to schedule, and you guys got into a huge argument as to when the motion to dismiss was going to be actually made, right? I mean, that's where the heart of this argument is, not on the preliminary injunction motion, which is where you want us to stop a sister state from hearing a case.
Respectfully, no, Your Honor. And
Because you can then, but the last point I want to make is you can then run over to Washington State and say, you know, Washington, please, you know, stay your action while we're moving the dismissal. We're going to handle the dismiss motion in New York.
Respectfully, no, Your Honor, because in doing so, that would allow, I am certain, if you don't grant us this relief, we will be irreparably harmed.
How?
Because Space Needle will move forward in the same way that the Madden court talked about the irreparable harm being obvious. Justice Capula, where she said it's obvious that the irreparable harm will come if you don't.
What is the irreparable harm?
Irreparable harm is having negotiated, agreed a New York choice of law form, having the parties waived any right to challenge that form.
That's not irreparable harm.
I'm almost there.
Okay, just
we
get
will
to
be
it.
subject to a jurisdiction's laws that is notoriously anti-insurance company, as opposed to the laws of this state, which are even-handed. Those include enhanced damages that do not exist under New
You
York.
know, irreparable harm is like when the wrecking ball is about to hit the building. If it hits the building and that's the end of it, you cannot recover the building. That's irreparable harm. What you're talking about sounds more like legal analysis, or legal,
To me, it's irreparable harm if a contract that was priced and negotiated under New York law and forum is subject to laws that the parties didn't agree to and specifically waive the right to use. And to me, the irreparable harm is that will put us in a jurisdiction that is absolutely different than what the parties agreed to in the terms of the contract. And if you start looking at other states' laws, every time a contract comes in with the New York Choice of Law and Forum Clause, you're in direct contravention of what the General Obligations Law says, what Madden says, what Amazing Homes says, and what ABB say. They all say the same thing. This is New York. The Washington state laws, for example, in Berkeley, are irrelevant to the question. I see my time is up.
Yes, okay, you'll have 2 minutes after we hear from the respondent. Thank you.
Thank you, Your Honors. Good afternoon. My name is Malcolm Seymour.
But
of
the
the law.
argument is well taken, Counselor. This was negotiated. It was negotiated not only once, apparently on multiple occasions, with that clause in the contract. So so what's the issue now?
Well, the issue is that there were two separate promises, and that was the distinguishing factor in this case that Justice Cohen thought separated it from the long line of cases that the plaintiffs keep coming back to, where ordinarily when a party comes to the court and asks for an injunction to enforce a forum selection clause, it's saying, hey, it's fair to hold the parties here to their promises, to their bargain. But what Justice Cohen found was different here was a prior prerequisite antecedent promise that Elite had made to the state of Washington, that it wasn't going to put clauses like these in its insurance policies.
Well, that's by agreeing to, in order to get permission to underwrite the insurance policy, they had to agree to whatever Washington state regulations are, and one of them was that regulation.
Exactly, there are two agreements here. And
Counsel, is that dispute between the state of Washington and North American? And so therefore, your contract can go forward and then the state of Washington can do whatever it wants to do to the North American, which is allegedly in violation and appears to be in violation of the statute.
I would not say so. First of all, the state of Washington isn't here to be represented, and so the Court of New York does have to consider whether it's going to be unjust or unreasonable, applying New York law to enforce this, when what's effectively happening in Justice Cohen's analysis is an end run around a Washington state law that this insurer agreed to comply with.
Counsel, I understand your whole premise about the two sort of promises made here, but the fact remains that you presumably know Washington law, and the clause was there, and yet you went forward with the contract. Why?
Well, so this is a separate question, is in terms of predictability, a Washington state insured and a Washington state insurance lawyer will look at a clause like this, and its expectation is that the clause is invalid.
Well, I mean, I think it probably would have been a better choice to call up the other attorney and say, look, I think we should knock this out of here. This doesn't belong in this case.
You've just heard from Elite's counsel that would have resulted in a price increase. And one of the things that
I mean, sometimes it's
yeah, I mean, then maybe you find another insurance
think about
company.
a sophisticated lawyer negotiating one of these contracts. Are they going to want to have to come back and trade something and give up some part of their bargain, some benefit of the bargain, to knock out a clause that they have every expectation under the law?
But counsel, I still don't see that you're really addressing the point, because the point again is that this is what you negotiated. This was in the contract. You saw it in the contract. You saw it more than once in the contract. You know you're in Washington state. So I do not understand why, you would not question it.
To be fair, Justice Cohen also raised this point, and he saw that there were considerations on both sides. But what the problem was here the plaintiff bears a burden, and it is a heavy burden on a motion for a preliminary injunction of showing that the balance of equities favors it and that it has a likelihood of success on the question of whether the enforcement of this clause is just and reasonable under New York law. He did not find that this was a clear-cut question. He didn't find that it had carried that burden. So this is not, Justice Cohen—
So the better approach, and that's why the better approach is to a motion to dismiss.
Clearly. This was simply something he was not prepared to say that he wanted to necessarily— he was understandably reluctant, faced with the posture of the case.
You filed that motion yet? Is that motion pending?
The motion for a preliminary injunction?
No, the dismissal motion.
The dismissal motion, I believe, remains pending, yes, Your Honor.
Oh, so it's been already made and submitted?
Well, I believe that there is a preliminary conference. I don't know, I believe an answer has been made, but I don't believe there has been a motion to dismiss.
All right, thank you. What's the irreparable harm? He's claiming he's going to suffer irreparable harm. You don't agree? That he's going to have to litigate in Washington state?
It seems to me that the irreparable harm they're complaining of is that they would have to comply with the law that they said that they were going to comply with. Now, they do argue that that's irreparable harm, whether it's cognizable.
You know how you can just resolve, the way I'm looking at it, I mean, not too long ago being downtown as a trial judge, why don't you stand down for a little bit and let them finish the motion to dismiss and see where it goes from there instead of pursuing two tracks? I mean, that makes some sense there, don't you think?
Well, then the question is, what is—
You wouldn't have to have this.
Well, what is the risk of allowing the Washington action to proceed while that's ongoing as well? The Washington action,
Well, what he said was that, what plaintiff's counsel said is that the two jurisdictions, the state of Washington and New York, deal with insurance issues and things very differently. And they bargained when they gave you this insurance policy that they were going to go to New York because that's where they very often go. You're seeming to suggest that that you knew about it because it was in there and you said, well, we're going to hope that some court is just going to ignore this because we don't want to pay more money for the policy. So it seems everybody's playing a few games here.
Except if everybody is playing a few games, that frankly cuts in our favor because we are not the party seeking to invoke the equitable powers of the court. They are. And if they are playing games and that is what this court believes, then they should not be allowed to do that.
So what about the Berkeley case that came from
Justice Etkin and
right here in the federal court?
That is a close case. Of course, it's not controlling, and they're happy to distinguish the Southern District case that goes the other way, which is the Seneca insurance case that we've cited. They're both persuasive. They both seem to come down a little bit differently on this question. Neither is controlling. And at the end of the day, Justice Cohen had equitable discretion here. There wasn't a case that dictated the result. The way that he distinguished the Berkeley assurance case, which is accurate, is again, we're dealing here with enforcement of the forum selection clause and not the choice of law clause. So he looked at the forum selection clause in Berkeley assurance, and what's different about that one?
That was not an exclusive.
Exactly right. It is a permissive clause, and the Washington statute is quite clear on its face that it applies only to mandatory forum selection clauses, not permissive clauses. This is a well-understood distinction. And so the Berkeley assurance case, as regards the forum selection clause, was simply not on point. It would have been persuasive at most anyways. But here what he had were Southern District cases that went both ways. In Seneca insurance, Judge Chin denied enforcement of a forum selection clause as unjust and unreasonable because it was a Texas insurance policy, a Texas insured, and the real property was located in Texas. And Texas, he found, had a sovereign prerogative in regulating insurance transactions in its own borders. Okay. He thought that was more, I'm sorry, Your Honor, I know that the red light's on and I'll step down a few. Any further questions? Okay. If there are any further questions.
Yes. One little wrinkle here is that, talking just to finish your thought there, is that in this case here, New York courts couldn't even apply Washington law, right? I mean, that's the whole dispute, whether or not Washington law or New York law applies, and we can't even do that because of the clause here prohibits that. So we can't even go through a conflicts of law analysis to see which has more interest, which has more at stake, correct?
That is potentially correct, yes. If New York courts were to apply New York law to the question of whether the choice of law clause is enforceable.
Right, because the choice of law here says only New York law applies.
Says New York, yes, right. Without regard to its conflict of law principles.
Correct.
And so, yes, the court's hands would be tied, and so there is irreparable harm on our side as well. Okay. Because we would lose all of the remedies that they've admitted we're entitled to under Washington law, and that we have an expectation, again, when we're talking about predictability of contract, that we have an expectation we'll be able to avail ourselves of as a property located in the heart of Washington State.
Okay, thank you.
Thank you, Your Honors.
Counsel, you have 2 minutes. Can I ask you something?
Yes, Your Honor.
I don't forget. You did say something, I believe, in your reply brief about a recent Ninth Circuit case. Isn't that correct?
Yes, Your Honor. I'm trying to remember it, but I remember there was a discussion of that.
In enforcing a mandatory New York, Ninth Circuit case where they recognized about enforcing a mandatory New York arbitration clause in an insurance policy based in Washington.
That's right. The Ninth Circuit recognized in that case that since it, like you, were the forum on a procedural issue of the enforceability, that it would not apply the Washington statute, it would apply California law. That's the prerequisite to this analysis is here in New York, and therefore the Washington statute should be disregarded, which is the same, respectfully, as the Berkeley case. And they have made a very big distinction between permissive and mandatory, but if you read footnote 6 in Berkeley, what Berkeley says in footnote 6 is that it doesn't matter. If it was mandatory, I'm still obligated to pay, or excuse me, I'm still obligated to apply New York law to the question. I don't go running to other jurisdictions. So since this is a procedural issue, New York law applies. And you
Does that
don't.
Ninth Circuit case also involve a preliminary injunction?
Yes, Your Honor. That's my recollection from the case. So to me, you know, you can get all caught up in these distinctions, but as Justice said, or His Honor said earlier, the question of whether we violated some regulation and there's a licensing issue is something that the Department of Insurance in Washington can decide to do something with or not. But what these very sophisticated parties agreed to do in a contract is to negotiate terms that said New York law only, New York form only, exclusive. We waive any right to challenge this. And this is an adhesion contract. This is a very big, sophisticated deal where they're represented by a very knowledgeable broker with global reach. And if we don't have contract certainty in New York, if we're going to walk away from Madden and ABB, an Amazing Home, and the other cases that this court has handed down, and start looking around to Australia or California to see if those laws might violate the New York law, then the whole concept of the general obligations law to make this a great commercial jurisdiction will be lost. And the whole process of understanding and making a decision about whether a contract is enforceable becomes completely convoluted.
Okay.
I'm sorry I ran over you.
No, thank you. Thank you. I just want to say, for me personally, I do appreciate that you both came in for oral argument on this case.
Yes, and we appreciate your having us, Your Honors.
Thank you very much. Appreciate it, counsel.
Thank you. Well done.